Hey guys, welcome back. David Greenberg here, freedomvibe.art. And this is going to be a part two of the last discussion that you guys saw between Brandon, Joe Williams, and myself, where we kind of dove in deep to some of the litigation that he's been doing, specifically with the Amex case. So if you haven't watched it already, definitely go watch the first episode because you're going to want to have that as foundational information. And I'm particularly looking forward to hearing from Brandon because he hasn't even told me the full story of what the updates are. So I'm going to be learning this new stuff just like you are. So we're just going to kind of continue where we left off. How you doing, Brandon?
Good. How are you doing?
I am doing really well, my friend. Like I was telling you during the pre-show, I just launched my new project, conditionalacceptance.com. We did a workshop this last weekend on my birthday. We had about 18 people. They stayed the whole time, which was amazing.
Wow.
And people got huge value from it. So I think we're off to a strong start.
Excellent. Well, hopefully I can this will be real killer for my audience because I've never ever talked about PACER anywhere ever. Because I wanted people to go and kind of figure it out on their own. So this is
Of
going to be
course.
for my people, they're going to go absolutely ape shit over this particular video. Because the last one we did, I've covered that on the Expanding Reality show. I covered some of that with Dr. Andy
Yep.
Kaufman. I've covered some of that stuff other places, but this episode that we're about ready to do is going to be my premiere pacer and basically like my first introduction into the docket and that kind of thing. A little bit more advanced, but very very useful. So I'm very excited to get started.
That's awesome, man. I can tell you're enjoying this process.
Oh yeah. At first I wasn't, but now I am, to be honest with you.
Okay. The honesty is good. Yep.
At first it was very, very overwhelming. I felt like I had been hit by a truck. But I got my feet, planted at least. Once you get some basic pieces of information that are really important and you kind of plant your feet down, from that point forward, any other confusions and stuff, it's a lot less intense.
Yeah, it's like anything in life. As you achieve mastery through practice, you reach a certain level of competence where it's just like breathing.
Yeah.
Amazing. All
Well,
right.
this is
Well,
going to be
don't
a
keep
long
us in sus
presentation. So you ready to get rolling?
Yeah, don't keep us in suspense. I already gave you permission to share screen, so you don't have to ask that for that.
Excellent. So here is the Williams and Williams law firm. Okay. And you're going to go to current and previous litigation.
Yep.
And you're going to see the case numbers and all that good stuff. So this video is all going to be all about how do we navigate PACER. Okay.
Okay.
So pacer.uscourts.gov. Okay. We're going to do so there's different things that you can do. You can sign up for an account. This is going to be the first thing that you're going to be signing up for. I am not going to cover this. This is if you can't figure this out, then I don't know how you feed yourself. So case search only is probably going to be what almost everyone is going to be filing for. Attorney filers and then non-attorney filers. This means filers meaning like you're actually filing into a case as the plaintiff or as a witness or as an interested party or whatever, right? So these two are going to be for a very small number of people who are either involved in litigation currently on the federal level or for people who are looking to litigate on the federal level, like what I'm doing. You're going to be using these types of accounts, but for 97% of people probably, or 95% for now. And I do believe you can always change your account style later. You're going to do case search only. Okay. Then after that, you're going to have access to search for a case. So now you're going to be able to do uh, all sorts of cool stuff, right? Now, we go to search for a specific court. We're going to go to PACER login. All right. And we're going to log in. Where would you like to go? Okay. Now, my case is, I shouldn't do this. I think it's, my case is in, I think it's Central District. Let me see here. Yeah. United States, Central District of California, Western Division. Okay. So we can type in California.
And this is the same Amex case that we've been talking about, right?
Yeah.
Okay, great.
We can get into my other cases. I have one in Minnesota and one in Texas, but we'll just stick with the MX case. It's got the most exciting shit happening in it, in my opinion.
Awesome.
So you can see here, we've got the California Central District, we've got the Western District, we've got the Northern District, and the Southern District. So you got to ask yourself, now this is more like Joey Kimbrough, my right-hand man. He knows how all that works and which one do you file into and blah, 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 blah. But uh, whatever, if you can't figure it out, that's a whole nother video. I'll be doing a lot of videos on this later when I kind of fully nail all this down and how all this works. But for now, I know my case is here. So we're going to log in. As you can see, the system that they use looks like it's from 1995. Okay, and that's just the way it is. There's nothing I can do about that. This is just a notice page
That's
of
probably
some.
because it is.
Yeah. So we're gonna go to click on this link to go to the document filing system. Okay.
Yeah.
Now this is the system that you are going to see when you log in. Okay. So when you log in, you have all these different things up top, right? You have civil, right? And I'm just trying to remember, here's search. No, not search. I'm trying to remember how to do all this. Let's see here. Query. Yeah. So if you go to query and we type in one of my case numbers. Oh, by the way, when you sign up for PACER, you'll get you either have to type in your credit card information and that will instantaneously verify your account, or you can request them
You
to
get a
send
code.
you a
Yeah.
code.
That's
The
how I
code will
did it.
come in the mail. You type in the code, and then as long as you spend less than $30 per quarter, you never have to type in any credit card information into PACER. It's free, under $30 per quarter. If you're looking up tons of cases and stuff and you go above that $30 per quarter, you will need to type in your credit card information in order to access PACER. Okay. So I just copied and pasted that case number, find this case. Okay. Let's see here. Oh, whoops. That's the wrong state. So we're gonna find my case number here.
User error.
I'm not super familiar with all this. That's why I haven't talked about it too much, right?
Yeah, for sure.
Okay, we're still having troubles. Okay. So let me see here.
I think
Query.
you just didn't copy and paste it.
No, I did, and it cut it short.
Interesting.
Oh, wait, maybe run query. So you just type in the case number, it'll cut it, and then you hit run query. Let's see what happens. Okay. So sorry, I like I said, I haven't talked about Pacer stuff too much because I'm still learning it myself. Okay. So I copied, I pasted it, and then it cut it, and then I just hit run query on the bottom because you can see
It's like an old 1990s program where you have to
yeah,
press
and
run query.
you can search for causes of action, name, prisoner ID, you can search for all sorts of information, but keep in mind you're only searching within the
The jurisdiction that you're looking in.
the Central District of California
Yeah.
federal cases. Okay, if you
Okay.
want to do state cases or other types of cases, you have to search. And I'm sure there's ways you can go online and you can type in God knows what like maybe Brandon Joe Williams v American Express. Maybe if you just type that into okay. So
Look at
so
that.
this pops right up. Negotiable instrument case, right? Oh,
Interesting.
there's a Reddit about me. That's hilarious. So you can
Sovereign
go
citizen, of course. They couldn't even get that right.
so fucking ridiculous. So fucking ridiculous. I'll have to check that out. It's
Yeah.
funny. So we have here Brandon Joe Williams versus American Express Company, right? So you can take this case number right here. So you can type in any case number. You could type in anything. You could type in, let's say, a lot of people, oh, Wesley Snipes, blah, blah, blah. Okay. Wesley Snipes v. United States. Or actually, it would be United States because they're the plaintiff v.
Hmm.
Wesley Snipes. Okay. So if we go down to find the case number, um, let's see. Court of Appeals. Court of Appeals.
So is the docket number the same as the case number?
I don't know. Let me see. Case.
Seems to have a similar format.
So let's see if we can find this docket number. Let's see if we go to query. We would need to go back, I think. We would need to go back to PACER and then go to search by a specific court, PACER login. Where would you like to go? We would go to Court of Appeals, 11th Circuit. Appeals. Oh man, I am not that good at this. Let's see. Oh, here we go. Appellate Court, 11th Circuit. Let's see if this will work.
There you are.
U.S. Court of Appeals, 11th Circuit. Submit.
Interesting.
So now we're going to go to the document filing system. Search for case information, case number, search. Okay, we do not have the correct. Let's see here. Oh, this is it right here. Maybe this is it. Let's see. Oh, whoops, I'm getting hit by this bar. Let's see. Let's try this. Okay. Let's try this. Okay. So I don't know how to find this case, but I know this is how you do it to some degree. Let's see if I can find this.
But it looks like you were able to find your case, right? I saw it come up in the when you hit query.
Yeah. Wesley Snipes case number. Okay, let's try this. Okay. Middle District of Florida. Case number here. Let's try that. PACER. Okay. PACER login. Where would you like to go? Middle District, Florida. Middle District. Let's try that.
Interesting.
Middle District filing system. Okay, now we have this upper bar again. Now let's see if we can run a
Slightly
query.
different for each one, it looks like.
It's different for each one. Find this case. Ba-boom. Thank God. I look like a fucking idiot here. Okay. So now we're going to click on, I guess, this first one. I don't know. There's a couple here, but we're going to click on this first one. We're going to go down to run query. Okay, boom. Now we are officially inside the Wesley Snipes case. Okay. So USA versus Snipes et al. This is from April 5th, 2006. Now, these are all the different things that you can do involving the case. The first thing we're going to do is we're going to go to docket report. This is asking you what filings into the case would you like to see? And we're going to type in absolutely nothing and we're going to hit run report. We want to see everything ever filed into the case. So we're going to go down, down, down. Has all the information about all the lawyers, all the good stuff. Blah, blah, blah. He was imprisonment, 12 months, blah, 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 all that stuff. Okay. Now go down, go down, go down. bunch more information, a lot of information. Wow. Okay. Okay, here we go. This is what a docket looks like. Okay. So this is every single thing ever filed into the case, and it goes by these numbers.
Yep.
1, 2, 3, 4, 5, 6, and you can see they're clickable, and we're going to get into that in just a moment. Okay. All the way down. Dun, 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 dun. I know this is overwhelming, but there's no way to show this or explain this without going through this. This is just kind of the way it is. You will probably be overwhelmed. Okay, get over it. I don't know what to tell you. So obviously he lost too. So, it doesn't need to be this many filings, but we're just taking a look at a very large case that was obviously mishandled because he lost in a case that it's really not that hard to win in a case like this, in my opinion. I mean, you have to know
Sure.
what you're doing, right? So this is obviously a massive case. I mean, my case, we'll look at it. So we're 602 filings into the case. Okay. Now let's say we wanted to. Now, if you wanted to download this whole case, it would cost you way more than $30. Like, I don't know, probably
Yeah.
hundreds and hundreds of dollars. I don't even know how much. Okay. But let's go ahead and just download the original indictment. It says here indictment, right? We're going to click on this little 3. Now it's telling me that it's going to give me this document. It's 4 billable pages and it's going to cost me 40 cents. Would you like to do that? Are you accepting charges shown? Yes, I am. View document. Boom. So here is what I would assume, because it's one of the first things filed into the case. This is the original indictment on Wesley Trent Snipes, Douglas P. Rosile, and Eddie Ray Kahn, right? And this indictment was, let's see here. They did make and present cost to be made and presented and aid and abetted the marketing and presentation of materially false, fictitious, and fraudulent claims for payment upon and against the United States, presented to the United States Department of Treasury, Internal Revenue Service, IRS, to knowing that the claims were false, fictitious, and fraudulent. Yeah, so in fictitious cases and fraudulent cases and fraud cases and stuff like that, intent is a big part of it. So they're saying that in this indictment, it was a knowing that the claims were fictitious, fraudulent, etc. Right? So you can read through this, and you can read that this is the original indictment. Okay, and you can download this document. This document is a PDF that is opened up in my browser. You can see, so I can just hit the download button here or the print button here. So basically, what I'm trying to get at with this is that litigation in 99% of all litigation in this country is like a televised UFC ring. It's a little bit hard to find out which channel which fight is on, but basically, like every single piece of paper and every single thing, I believe even transcripts of like hearings and stuff like that can be ordered by anyone. I don't know that for sure, but I'm like 90% sure anyone can order transcripts. Transcripts are pretty expensive, by the way. You can spend $200 or $300 on a set of transcripts for like one hearing. But my point is, it's all accessible and it's completely public, and it is essentially warfare. So what you're looking at is you're looking at the system, of which is the TV channel, of which you can pay per view to view all of the blows and attempts to defend and swings of the axe and punches and pile drivers and defensive moves and everything else. In my opinion, and the way I would describe all this, that's what this is. Okay. Now,
Okay, so hang on. I've got a question.
yeah,
And hopefully we're going to see your case. We're going to search again by your case because I'm very interested to see it personally. I'm sure the audience is too.
yeah.
Um, how likely do you think it is that you will actually end up physically in court versus just dealing with all of this on paper?
I would love to because I need to learn. So I would like to try to get there as quickly as possible. I don't recommend that you litigate if you're terrified of that. But to answer the question, I would say I have not gone to any court. We haven't even done, I did one meet and confer over the phone, audio only, one time with two attorneys in all four cases, and it's been 2 months.
Okay.
Everything else has all been paper into the docket.
And was that meet and greet or whatever it was that for this Amex case or was that for a different case?
No, that was for my very, very first case with Compass Realty and Dan Hollerman.
Yep, I remember when you described that one. Okay.
So that was a meet and confer for that case. I've been trying to get a meet and confer done for the MX case, and the lawyers are going absolutely ballistic, which we can get into. We can get into that now. So I'm gonna go. I don't know of any better way to get out of this. I could be, again, anyone watching this who may have experience with PACER, it may look like I'm an idiot. I pretty much am. So that's okay. I'm not attempting to, I know the law pretty damn well. I don't know PACER all that well. So I am just want to be transparent. So we're going to go back to the login, I guess. Where would you like to go? We're going to go to California. Mine is the Central District. Submit. Okay. Now I have the ability to actually file into my case. So if you have the ability to file into a case, you would go here to civil, and then you would go to, like, what are you filing? Are you filing a service of process, meaning did you serve the summons and now you need to file that you completed that action? Are you filing a motion? Are you filing a discovery application, discovery requests? Are you filing here's other types of filings, stipulations, transcripts, notices, bonds, appeal documents, right? So let's say I wanted to file a motion. I would go here and it would say, and I already have my PACER account is already linked to my account. So it says filing in case, and then you hit next, right? And then it says the case number next, and then the first thing it asks you is, what are you filing? Motion, hit next. What kind of filing for a motion is it? You can say like a motion to appear, motion to find someone in contempt, motion to compel arbitration, all these different kinds of motions. So if you aren't sure what kind of motion that you need to file, this list may actually help you. And again, I know this is overwhelming. That's the way it is. You just have to slowly make your way through this. If you think that attorneys know more than maybe a few of these or a handful of these, you're very wrong. Most of this is not used by most people most of the time. So it may look like a long list, but whatever. Okay. And if you don't know, then you just find the one that's the closest. And there's actual case law that pro se litigants, they have to go pretty easy on you as a pro se litigant. It's one of the huge benefits of being pro se. Or sui juris. I know there's been a lot of talk about that too. Is it sui juris? Is it pro se? Doesn't fucking matter. I hate that stupid fucking question. That's a question that is asked by people who are not litigating and will not litigate. They're fucking retards and they piss me off. It doesn't fucking matter.
What's the question?
Pro se versus sui juris.
Ah,
Doesn't matter. I'm not litigating as myself as a natural person. I'm litigating via the all caps and
but you have
legis.
to because that's the
Yeah, I don't care.
Caps is in the
Pro
jurisdiction.
se is fine when you do it that way. Who cares? I'm not even in the fucking courtroom. It's the fucking all caps name that's in the courtroom. Why do I give a shit? I could care less.
So
So,
if someone filed a lawsuit against you, it would actually be against your all caps.
well, it is against it. It is either way, whether they want it to be or not, doesn't matter, right? So back to this. So let's say you wanted to file a motion to dismiss a case, which you shouldn't be doing, by the way. You should always counterclaim. Always, 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 unless you fucked up real bad and you really did fuck up and you really are fucked. Besides that, but anything financial, anything involving the system and the matrix, you should always be counterclaiming. I mean, I don't see why you wouldn't counterclaim under literally almost anything that could possibly happen to you. So let's not use dismissal because it irritates me. Let's use default judgment. So we want to, so you filed a lawsuit against somebody, they never filed in, and now you're going to file a motion for default judgment, right? So you would just do default judgment, right? And then you hit next down low, and then you hit next, and then there's going to ask you who's the default judgment on and who's writing this, and you would say the plaintiff, and there's a bunch of different windows. And then the last window is to upload your documents, and then you hit next, and then you can file the documents in, and then they get filed under default judgment and all the information that you typed in on the thingy. Okay. So that's what this is. When you have these things linked to your PACER account, you can do all your filings and you can do all this cool stuff here, and you'll get emails every single time something gets filed into the case. And if the clerk files into the case, you'll get an email. If the judge files into the case, you'll get an email. If the defense attorneys in my situation, because all my cases on the plaintiff or my clients are the plaintiff, we get an email. Okay. So it's pretty cool. You don't have to worry about mail. You don't have to worry about missing something as long as your email is functional. You know, you can list the court as a priority, and you can save their information to your email and mark them as priority and then mark them as pinned. And then every single time they send it to you, you won't miss it. You'll get a pin, you'll get this, you'll get that, you'll get the whole thing. Okay. So going back to the query. So let's go to the query. We're going to look up my case now. Okay, this is the Brandon Joe Williams, all caps, registered trademark versus American Express Company et al. They misspelled the name here. But you'll see in the docket the correct name. Okay. So I just typed in the case number. It like cut the last part off automatically, which is fine. I guess it still comes up. So we're all good. It's asking me what inside this case would you like to be looking for? We're not going to specify anything. We're going to just go ahead and just run the report, just kind of raw dogging it. Boom, here we go. Now we're inside the case. And you can see it says here pro se, right? So we're going to go down to look at the docket, right? And here's the docket. The docket is 28 filings deep. You can see that my first complaint was filed by me on February 26th, 2024. So just to give you an idea as to how I think all of these cases are going to go, the 28 filings deep, and you can see here minutes in the chambers. The court has basically stopped us from filing anything else in the case. So they're saying here, if defendants wish to file opposition to plaintiff's motion to strike, no reply briefs shall be filed in support of the motion. The hearings on plaintiff's motion to strike and defendant's motion relief have been vacated. So basically what they're saying is like, all right, let's wrap this up and then give it to us, and then we're going to figure out what the next step is, because obviously this isn't going anywhere. So we're 28 filings deep into the case, and the train hasn't even left the train station. Literally, the train.
So does that
the train isn't even on. The train, the engine of the train has not even really been started yet. Barely. You could say the train is ready to have the engines turned on, but we're not even at that point yet, let alone leaving the station yet. Now, I'll cover how that is and why. We have to go through the whole case to kind of figure that out. Okay.
Okay. So quick question.
Yeah.
When they stop motions, is that for both parties or just for you as the plaintiff?
Whatever they order, whatever the court orders.
Okay.
The court can order anything. You never know. I mean, you know, when you start to get used to how this works, but so you can see here's the complaint. We went over that last time on the first video. Here we have a certificate of interested parties. Here we have an application for me to electronically file into the case, right? Here we have a 21-day summons that was issued by the court. Here we have an assignment of a judge. Here we have notice of consent. Here we have notice of parties to of court directed ADR program. I don't know what that is. And then here we have an order granting application for pro se electronic filing. So this is where my electronic filing was approved. Self-representation order, which doesn't really make sense because I'm not technically representing myself, but that's okay. Everything in my documents are very, very clear about that. So they can just kind of run it however they want. The documents are very clear. Notice and acknowledgement of service. So this is the affidavit that I filled out and sent in when I had finished processing the we can download that one. We can take a look. This is the let's see here. View selected, right? Right. Okay. So we're going to view all these documents all in one PDF, which is really nice. So we're just going to wait for that to load for a moment. Okay, so now we're looking at notice of service of process. See, it says Brandon Joe Williams in all caps, by and through Brandon Joe Williams, agent, pro se. So the way this really should have my registered trademark symbol on it, it usually does. This one doesn't have it for some reason. This is just, it was served, blah, 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 and then it's got my info, right? And
What's the
then,
implication of your registered trademark? Doesn't that have an implication for them in terms of usage?
well, it's on 95% of everything.
Okay.
So then this one, Joey Kimbrough, right, not a party to the case, blah blah blah. He sent us a copy of the summons through through mail, and that's just him, saying that he did it, right? And then we have the same thing again, Joey Kimbrough, and then we have the evidence here, Exhibit A, which shows that it was stamped and received by the two organizations, Cabbage and American Express. Okay. Now, what happened was is the even though that I guess it's legal to serve through U.S. mail, they weren't too thrilled about that. So the court um, said here, this is from the court minutes and chambers regarding notice of service. Defendants Amex and Amex Cabbage are corporations. Therefore, there's a certain local federal code, federal rule that applies. And it says here, it appears that plaintiff attempted to effectuate service of the summons and complaints under defendant's agent for service of process. Um, let's see
So
here.
basically, certified mail didn't cut it for their.
They didn't like the certified mail, even though, as far as we're concerned, it's fine. But there was some federal rule. So I have here, and I know this is a bit sloppy, this video, but I'm just now, like I said, I'm just now starting to talk about this stuff for the first time. So we're just gonna, I might be a bit sloppy for a while, kind of like my free contract killer course. It was pretty sloppy, and now I'm not as much, right? So this is the Federal Rules of Civil Procedure. And I know it's a lot, but a huge chunk of it is just the whole kind of breakdown at the beginning, right? But you go down and you start to see that there's these various rules, Rule 19, Rule 23. These are the various things they're talking about. And the way that the courts operate is these local rules or federal rules are actually laws, according to them. So I have the California Rules of Civil Procedure, local rules for the Central District of California, for my district that I filed in, right? Now, luckily, typically you're not going to be filing in a whole bunch of different districts, and even if you do, they don't change a whole lot. But when you look through a lot of my cases, you're going to see that they're talking about these local rules, right? And what they're saying here is just basic information as to like when you file, like this is the one that we file, you'll see this one in there, evidence on motions. It's just saying that, factual contentions involved in any motion and opposition to motions shall be presented, heard, and determined upon declarations and other written evidence, including documents, photographs, blah, 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 blah. So typically as a pro se litigant, they're going to go a little bit easier on you with a lot of this stuff, but you do need to look over some of the stuff. And when they mention it, you need to look through this stuff. Like this is a really important thing. You're going to see this. This is like almost the entire spinal cord of almost everything we filed with so far, 28 filings deep. So, um, in all cases, um, except in connection with discovery motions, um, for temporary restraining orders, preliminary injunctions, any motion must first contact opposing counsel to discuss thoroughly, preferably in person, the substance of the contemplated motion and any potential resolution. So typically, this is called a meet and confer. And this is like the basis of everything that's going on in the Amex case right now. So the defense attorney is very new. I can show you who she is and what she looks like and that kind of thing. She's listed publicly on a law firm website, right? She filed a motion to strike, a motion to dismiss the case, and she never had a meet and confer with me. So she's not familiar with this local rule. Now, as I'm learning more and more and more as I'm going through this, the attorney will do anything to just do whatever they want, and it's great for us
Like
actually
they're
because
throwing darts and just seeing if they can hit the
yeah,
board.
they don't have a clue. Like I said, people think that these attorneys have a clue. They don't have a clue. Nobody has a clue. So when you go in and you start reading these things, you already know more. I mean, you already know more just understanding basic terminology. But now if you go in and start reading the local rules, now you're really going to know a whole lot more than them because they don't follow any of the local rules. Okay. And when you do, it's taken very, very favorably by the courts. Okay. This is basically law. So when I filed my motion to strike their motion to dismiss, which just means I file a complaint, they file a motion to dismiss the complaint, and then I file a motion to strike the motion to dismiss. So everything is like, so the way it works is if someone files a motion, the way it works is the other party can respond to that motion, and then the initial party can respond to that response.
Sure.
So whoever originates the original communications or original motions is typically in the best position because they get up to bat 2 times, whereas the person on the other side of the equation is up to bat 1 time. I think a lot of that has to do with just the basic structure of the court system, and like basically you've probably heard down the grapevine that like being the plaintiff is always better, and being in the offensive position is always better. Well, it is factually better.
Of course.
Because you're up to bat twice. You're the one filing motions. You're the one doing this. You're the aggressive person on the offensive. And when you're the aggressive person on the offensive, you get to file the motion. They get to respond once, and then you get to respond to their response. But then they can file a motion too, and then now they filed the motion to strike your motion for dismissal, and then now they write up that motion to strike, and then you can respond to that motion to strike, and then now they can respond to your response.
It's like playing tennis on the court.
It's like playing tennis, right?
Yeah.
So when you realize that's how it works, that's how you get 28 filings deep into a case, and the engine of the train hasn't even started up yet. So one of the issues here is that this local rule was not followed by the defense attorney. I've tried to, and she's trying to get around it. She even wrote a request to have relief from local rule 7-3. And she said because she's attempted to have a meet and confer with me, which is ridiculous, she has not.
How can they prove that even?
It's ridiculous. I'm telling you, most of all this litigation stuff is just dealing with children, which is hilarious because an attorney at law is supposed to represent children and retards. In my opinion, they're worse than their own clients. So
would you have met with her if that?
Oh yeah, I would drive all the way downtown LA on my motorcycle and go in person. The court says preferably in person.
Got it.
I'd love to do a meet and confer. I'll go down there. There could be 30 fucking lawyers in a room. I'll walk in there by myself. No problem. No notes, nothing.
It's all about being certain about your case and the fact that you're in the right.
Yeah.
That's the bottom line.
So getting back into this, we ended up using a process server, and let's see here. This is when we have Brianna M. Bauer filed into the case as the defense attorney.
She's the one you mentioned.
She's steptoe. This is her right here. Now you can see from her information, she's fairly new. Let me see here. You can see graduated in 2022.
Oh, wow.
She's a very new attorney, which is probably why she was put on the case, because pro se, it's like just an annoying bug that's kind of flown into your space, and they're very easy to manage and handle.
And they
So
assume that you're just like any other pro se
exactly,
litigant.
they assume that I'm like any other pro se litigant, and they're like, "Oh,
Yeah.
here's a great opportunity for a new attorney to learn some things,"
Yeah.
and now she's in deep
She just
shit
realized
because
how
she
deep in
fucked
the
up.
doo-doo she's in.
Yeah, which is great for me. It's great for me, right?
Yeah, of
And I don't have any bad feelings toward her or whatever. She's just trying to
course.
learn. You know what I mean? So, the first thing that was filed by her was the motion to dismiss the case. They're always, and I got to tell you guys this. I have a lot of people who call me, or I don't want your calls. I have a lot of people who uh hit me up or whatever, and I'm telling you, uh you um they are always, I feel like if you don't have a decent case, they may not. But if your case is actually decent, they're always going to file a motion to dismiss. Even if it's the dumbest, goofiest, most hollow, most ridiculous, most untrue, worthless piece of shit thing you've ever seen in your entire life, they will file it. Always. You could have a smoking gun, a dead body, and 4 signed affidavits, and they're still going to file a motion to dismiss.
But don't they have to have some basis for the reason why they would dismiss it?
Yes, but they'll just make it up.
Okay.
They'll just make it up. They'll do whatever. They'll figure something out. They'll figure out some local rule that wasn't
A
applied,
technicality, for
some
example.
technical, anything they can find, they are always going to
Interesting.
file a motion to dismiss. You can literally, you shouldn't even file your initial complaint without already thinking how the motion to dismiss is going to look like. You should already be preparing for the motion to dismiss even before you file your first complaint.
Interesting.
Always 100%. Unless it's like you want something off your credit report and you're not even asking for money and it's like legit and it's simple. We Joey has one case he's doing that with, and they didn't do a motion to dismiss. But anything of any substance at all whatsoever, anywhere, under any circumstance or subject, anywhere, anything, I would recommend that you literally just know for a fact 100%, no matter what, they're going to file a motion to dismiss. And all the motion to dismiss on all of my cases have all been failure to state a claim for which relief can be granted. What that means is basically you just said some stuff that they can't even do anything with, and or that you don't have the right to go after or something like that. Failure to state a claim for which relief can be granted. And you can look that up, and you'll see that even here, what we're going to look at here, right? So this is the
It's like
motion to
saying there
dismiss.
isn't a basis to the case.
Yes.
essentially.
Yes. And all 4 of my cases, it's always the same shit. They just say a whole bunch of case law and they just go on and on and on about a bunch of bullshit. And they just kind of hope you don't respond. If you don't respond, they win and they dismiss the case. They could say anything. They could say that because the sky is green, because the daffodils grow, this really should be thrown out. And if you don't respond, it will be thrown out. That's how it works. That's why I believe this is why I believe the definition of the word responsibility comes from law, and it means able to respond. You want to respond in opposition to everything. If they sneeze, you're going to file in opposition.
So that's important to clarify. When they file a motion to dismiss, the onus is on you to make a counter.
If they file anything,
yeah.
If they breathe into the docket, you're in opposition.
Okay.
And
So
you'll see that.
The judge is not making
the judge has not said a fucking word, and we're 28 filings deep, and we're a month and a half into the case.
And this says May 6th. So this motion was filed today? It says date May 6th.
No, this is when the defense attorneys were originally trying to create a hearing for dismissal.
Okay.
So dismissal hearing, right? But that May 6th thing was canceled.
Got it.
The date of this is, well, actually, this might be from the. I'll explain this to
April
you.
3rd.
So
Yep. Okay, I got it.
so this is the response and the request for dismissal of my case, right? Uh, so the way everything works in court, and this is also going to clear up a lot of things, is you're going to do everyone's job for them. And you can complain and you can bitch and you can moan and you can freak out and you can go on Reddit and you can file about how this is ridiculous and this is how the court system should be. You could start up a nonprofit organization that says that, it shouldn't be this way. And you can spend all your money for the next 20 years and you can get billions of dollars in donations. And I still don't think this will ever change. You are doing the job of the judge for them. And you can see that here. So what the defense attorney has done is she wrote this up. And she basically wrote it up. Let me see here. See, this is from April 3rd.
Not too long.
So I don't know why that hearing is in here. So, but anyways, what I was trying to say was, and I'm going to see if we go all the way down to the bottom, is probably a proposed order. Yeah. Here's the order. Okay. So a proposed order granting American Express's motion to dismiss. The way it works is she says this is bullshit. This should be dismissed because the plaintiff failed to state a claim for which relief can be granted. And she cites all this case law and she does all these things. And then what she does is she goes through this whole document and she talks about how each cause of action it does not state a claim for which relief can be granted, right? And
Interesting angle.
so she's going into all these different things about blah, blah, blah. He didn't send anything of value. This is a vapor money theory, blah, 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 blah. And then she's getting into how a lot of these things are criminal and like blah, 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 blah. And you can read through this and you can see all the different points as she's saying as to why this case needs to be dismissed. And she has to go through every single cause of action. And she has to explain every single cause of action, which is why I say if you can have 17 or 18, they got to be real. But if you can have 17 or 18 causes of action, it's great. Because if you get any of them to hook, you can pull the case into discovery. You can pull the case forward up and out of this. What Dr. Graves calls, this is called the flurry of motions. Whenever they come in here and they're always going to do this motion to dismiss, and they're going to do whatever. They'll make shit up. They'll do whatever they have to do. And they'll just put whatever bullshit on there, real or unreal, doesn't matter. They'll make it sound real if it's not real. That's what they're good at. And they go through every single cause of action. And she's describing every single cause of action. And then after that, she's going to do the job of the court for the court, right? So this motion, as per local rule, has to have a declaration. So this is her declaration as per that local rule we're looking at that says you have to have declarations with motions, right? Oh no, that's a certificate of service. Sorry, that's a little bit different. Wait, notice of motion and motion to dismiss, memorandum of points. Yeah. So here's the proposed order. So the way it works is you are doing the court. So she wrote this. The defense attorney wrote this. So basically what she's saying is these are all the reasons why this case needs to be dismissed. And then here's a proposed order. I've already done your job for you,
You're
Judge.
keeping her employed, Brandon.
Yeah. Well, that's the thing. All these attorneys that you're going to be dealing with as a pro se litigant, they love you and they hate you. They hate you because they want to destroy you, and they love you because you're the one paying all their bills. So it's a love-hate relationship. People think that they're big and scary. People think that they hate you. A lot of it's just an act. There's a huge part of them that love you because you are paying all their bills, especially with these gigantic cases that drag on and on and on forever. This is absolutely perfect because most attorneys get paid on what's called billables.
Sure.
So what they want to do is they love this kind of shit, and they want to write up all sorts. They want to get all sorts of bullshit and put it in there, and they want this case to drag out until the end of the earth. So you have two issues. The main issue you're going to be dealing with when you get into litigation is not necessarily winning or losing. It's the fact that the attorneys, the defense attorneys, they'll just make shit up left, right, and center, because that means there's more shit to talk about. More shit to talk about means more billables.
So I guess the question would be, from a strategic perspective, how do you stem that tide?
You can keep things short and keep things pithy, and you can just annihilate things. And what I do is I always try as much as I can to just redirect the case back to getting the complaint answered. You'll notice in all my cases, none of these attorneys want to answer my complaint, and that makes perfect sense, because if they answer it, they're gone. They're done.
It's a lot of redirection and misdirection.
So basically, everything you're going to see in all four of my cases is nothing but frantic, psychotic redirection.
Yep.
Like massive psychotic redirection. Like, just, oh my God, we'll do literally anything to not have to answer the complaint. And when they do a motion to dismiss and they say this is all BS, if it gets approved, and this order that she wrote, so she writes the order, it's a proposed order, and then all the judge has to do is just sign it and then date it, and boom, it's done. You see? You're doing the job for the judge all the time. A motion to move the case into discovery will have a proposed order attached to it. And now this blah date of blah, upon consideration of blah, the motion for discovery is approved because it looks like we need to dig for more information, and I see like a real real merit to this case, blah, 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 dated and signed, or I don't know how it would look exactly. I'm just making that up because I haven't gone into discovery yet. And then, so it would be a motion for discovery. It would be all the reasons why the case needs to go into discovery. It doesn't need to be, it could be just one sentence as to why the case needs to go into discovery. It doesn't need to be this fucking long thing that she got a lot of billables for this. See? So you're going to see all this and you're going to be like, oh my God, I have to read all this. No, you don't. This is all just billables. You're just looking at billables.
Okay. So I was watching, just to interject real quick anecdote. I was watching a video about common law and being in court under common law. And I apologize, I can't remember. I have it in my watch history. I can't remember the name of the fellow, but he apparently, as a non-judge, was making orders in the court and they were sticking. Have you come across this?
You can write.
Yeah.
So the way that the court system works is, she wrote this. I've written a bunch of orders too.
Okay.
The judge hasn't signed a goddamn thing on either side. I've written orders. I've written orders to strike this whole motion to dismiss. I've written orders for sanctions. You're going to see that. Orders for sanctions means like Brianna Bauer is going to get hit with monetary fines for not following local rule 7-3, for not having a meet and confer with me. Okay. So sanctions is when laws and rules are basically like knowingly and willingly violated, and it's basically disrespectful to the court, and it's disrespectful to the law. And you can write now defense attorneys and prosecuting attorneys, they talk about sanctions like it's lollipops. Oh, you're filing a fictitious thing and it's frivolous and you're harassing my client and we're going to file for sanctions. We're going to file for unlicensed practice of law. We're going to file for, and it's all bullshit. They'll say anything. I've heard more. I didn't even know the definition. I had never heard the word sanctions until I started getting involved in litigation. And I don't think I hear words more than sanctions now. Everything's a fucking sanction. Oh, yeah, fucking sanctions. All they do is just intimidate and threaten you. And I think the reason why that is because they know that A, they don't have a clue about anything I'm talking about in my complaint. B, if they do, or if anyone does, if they answer it, they are literally going to get wiped off the face of the earth instantaneously, because whatever they answer as affirmed is basically proven. And I've written in a way where good luck. So the thing is that they do this and they threaten and they intimidate because that's all they have. And I don't know either A, they don't understand my complaint, which is most likely the situation, and they would never admit that because they're the
Can you give an
professionals.
example? I know you probably don't want to dive too deep in it, but from this motion, is there like a paragraph that just demonstrates just how much they're doing that? Like a specific, piece of that we could just see?
That's mainly over the phone and stuff like that. They don't
Okay.
they don't get into that too much on the docket because they like to bark when they know they're not being recorded.
Okay, but you said in this motion, like, is there a paragraph or an example here that just demonstrates that they're just trying to just misdirect and not really hitting the points head on? Even just
Well, I mean, yeah. I mean, you should go through the complaint. They say that for all of the Title 18 stuff, it's all like there's no private right to action. So what they're saying is that like I have to go through like a criminal court in order to hit people with Title 18 because Title 18 does not have like private citizens, quote unquote, do not have the right um
interesting.
to go there. I mean, you can read all this. You can they say that they're not I said breach of fiduciary duties and they said that, there's all this case law that talks about how a lender and a debtor, there is no fiduciary duty. And there's a bunch of cases where they talk about how when there's a lender and a debtor situation, the lender does not have a fiduciary duty. But then I came back and hit them with the fact that they aren't the lender. They say they're the lender, but they aren't. They're lying.
Interesting.
See?
That's a great way of
So
handling that.
everything is in
Yeah.
opposition. If they so much as even breathe, I'm up, they're breathing. I don't like it. I'm not into it. You see? They also said,
That was a good example.
yeah. So breach of contract, they're saying that they didn't breach the contract and blah, 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 because I sent in something that didn't have any value and because I'm talking about a vapor money theory and there's been all these cases, blah,
Which
blah,
they
blah, blah,
probably
blah.
made up. I've never heard that term vapor
I've
money.
never heard of vapor money theory in my life before I filed this case. I had never ever heard of the term vapor money theory. And apparently there are cases I didn't even look at them. I figured it's a waste of my time. Maybe I will. I probably will at some point in time look into them or whatever. I've maybe peeked a couple of them, but it's just not. So these basically what they're saying is that there is no breach of fiduciary duties because a lender and a debtor don't have fiduciary obligation. So you can see every single cause of action, I have an opportunity to win. I have an opportunity to hook the case. And once I hook the case, I can get the case to move past this point, and then I can get it into discovery. And I feel like I haven't gotten into discovery yet, but Joey has, and he tells me very clearly, and I've heard from many people that discovery is where you win the case.
Brianna, if you're watching this, you should just quit. You should just defect to Brandon's side.
Well, once we get into discovery, it's going to be very, very easy because then all I do is I don't even need to do a deposition. I can just write an interrogatory and I can just ask on the interrogatory to know all of the details step by step by step. Question one is going to be, were any promissory notes on this account ever collateralized? Question number two is going to be what happened with the collateral securities, and then I'm going to write an order to compel actual accounting information. That's going to show like that they use FedWire or the FedNow system or whatever system they use, and how the promissory notes are turned into a collateral security. I'm going to ask on the interrogatory for original copies of any application for notes that was ever written digitally or otherwise, as per 12 USC 412. I'm going to ask for an exact ledger that shows that this particular original promissory note or whatever was sent out, and then the promissory notes, the Federal Reserve notes, were brought back in. So like just that alone, without getting into anything else, I'm already gonna win the case. And that's just like one of like 400 different things that I have in my repertoire that I can use to win this case. There's no way this case can't be won. Absolutely impossible.
Brianna, it's not too late to defect.
Well, she's going to learn a lot from this case. She's going to learn a lot from this case. I mean, this is like, boy, I sure would love to learn how to swim. And then a helicopter takes you out in the middle of the ocean. You don't even know where the nearest land is, and you're just dumped in the water, and somehow you make it to land. You're going to be a world-class swimmer in fucking 2 days. So, this is basically what that is for her. So that's good for her. She's going to learn a tremendous amount from this case. She's going to know more than some of the attorneys that have been working there for years, right out the gate, right out of school, practically.
Very
So,
serendipitous. Yeah.
plus she's going to get billables because this case, I'm willing to take this case all the way. We have to go to trial and the whole 9 yards. It's going to be easy. Oh God, swaying a jury on this, if she is watching this, swaying a jury on this. Oh my God. I could wear a pink tutu, be drunk, shave my head, and get into a fist fight right beforehand, and have both hands tied behind my back, and I could sway a jury on this shit. Unconscious. You could wheel me in on a wheelchair, and I could fucking sway a jury on this
I
shit.
can see why part of you wants that to happen. And
yeah. Oh, dude.
Is it guaranteed that it is trial by jury? I mean, that's something you have to specify?
No, you have to request it, and then we move through the normal processes. We move through this, we move through discovery, and if we get through all of that, and it's still a justiciable controversy, then we would motion the court to trial.
Interesting. Well,
if that now the thing is, keep in mind,
I'll definitely be a spectator when that happens.
Oh yeah, it'll be like a lot of people probably. Well, maybe I'll you can write an order for anything. I could write an order to motion the court to trial, and then inside the order for motioning the court to trial, I could put another order that orders the court to be televised live on YouTube.
Amazing.
And I can give reasons as to why I believe that
you can have your own transcriber, right, as well.
Well, there's always transcribers, and then you can always order transcripts. So either way, it's recorded. But I'm just saying, if you inside
can bring
the order,
your own court recorder, apparently.
Yeah, you can do whatever you want.
Yeah,
and you can write orders for whatever you want. You can write an order that, let's say, for example, the defense on this one started calling me a sovereign citizen. I would write an order to bar any terms associated with sovereign citizen because that term is libelous and slanderous, and it's not based on fact, because I am not a citizen of anything.
Right.
So the thing is that would be an order that I could write to the judge, and I could be like, this is ridiculous. This is just used as some kind of like weird reputational attack. And I would say that it's irrelevant to the case, and it's just being used to misdirect the court and to basically piss on justice, right? And if I write that in an order like this, like what you're seeing on the screen right now, I would write all that in very like friendly, cool terms, and then dated, and then it would say Honorable Michael W. Fitzgerald, United States District Court Judge. And then if he sees that and he likes that and he makes sense to him, he signs it, and now that is an order of the court. But I did the job for him. You are doing the job for
you're the one who's
them.
making the order. But
you're making the order. You're making the motion. You're making everything. He reads through it. He or she reads through it. Says, yeah, I understand this. They're like a referee. This makes sense. Thank you very much. They sign it. Let's say, for example, you want to subpoena the Federal Reserve, which is something that I might do on this case. I want any application for notes or any security swaps requests, whether approved or disapproved, that were ever made between Brandon Joe Williams, all caps. I don't know if they're going to need the social security number. I don't know how they're going to process that exactly, but however they're going to process that, I need to subpoena the Federal Reserve to get those records, to place those records into this. So I would motion the court into discovery, and then I would write an order, or I would write a subpoena, and it would literally be the entire subpoena. And then at the bottom right, it would just say judge, blah, 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 blah. And if the judge signs that subpoena and gives it back to me, now I can serve it. I'm not 1,000% sure it's exactly how it works, but like that's the basic gist of how all this works. You're writing the subpoenas, you're writing the motions, you're writing the orders, and they're also writing motions, subpoenas, orders, whatever. And the judge is the one who decides what documents he's going to sign. But let's say he isn't sure. He can order for a hearing, and he can have both parties come together, and now we're speaking about it, and now there's a transcript being made, and he's going to ask questions or do whatever or do this and do that to collect the information he needs to decide what order he's a referee.
Yeah.
He's a referee.
Chris Hauser referred to the judges as a referee, and now when you describe it, like the process, like I don't think I really understood what he meant by that, but now when you describe the back and forth, it's just clear, even more clear that he is a referee.
Keep in mind, the judge has said nothing and signed nothing on this case at all. And there's been no hearings. There was a hearing that was set and then it was canceled. So just to keep in mind,
Hearing in this case is for what specifically?
it
Like,
could be for anything. Hearing for a motion, hearing for more information, hearing for, I mean,
okay.
I don't know. I'm kind of new to all this still. I would say even if the judge wasn't totally sure about moving the case into discovery or why, maybe he would call a hearing. I don't know anything. Could be a hearing for anything. It's
So
very open.
have you already responded to the motion to dismiss?
Yeah, so that was the 15th filing, and we're 28
Okay.
filings deep, right?
Okay.
So then she filed in, and you can see she's kind of new because you can see a lot of these filings are her revising old documents. Every time you see revised, that's her filing in a revised copy. So she's learning. She's learning a lot from this, right? Probably getting her head ripped off, but that's okay. She's learning at an extremely fast rate. And it's great for me because she's screwed up so many things already that I have a great foothold now on the case. So it benefits you dramatically because when they're fucking everything up, now you got to think an attorney at law, they are held to full standards. They are held to the full standards of the local rules of the court. They're held to the full federal rules of civil procedure. Now, keep in mind, everything I'm teaching you in this is on a federal case.
Sure.
PACER is federal cases only. So if you're doing state cases, it's a whole different system, but it's going to be like overall the same thing, but like the computer and like where you log in and all that. I don't know. I haven't done any state cases. I've only done federal cases. And the reason why is because negotiable instruments operate the same everywhere. We all use Federal Reserve notes, and they all notes and instruments all work the same way. It's all the same shit everywhere.
Yeah.
You endorse them, and then there's negotiability, and then there's this blank endorsement, special endorsement. It's all the same shit everywhere in the United States of America. So that's why it's a federal case having to do with negotiable instruments. Okay. So so I don't think I'll ever file an estate case. I don't see why. I mean, if I stick to, and that to me, I like that because I'm already fucking overwhelmed by all this shit. I don't want to have to figure out a whole state system. And then when you start getting into state versus state, and now all the states are different. And now you have to look into all that. On the federal, it's all federal statutes and it's just PACER. And that's it. Once you learn PACER and once you learn the federal statutes, bada bing, bada boom, you're all set in all states. So the federal courts are more expensive. It's $405 for a filing, whereas a state case could be $200 to $300. I don't give a shit. The federal courts have more resources. They seem to be better organized. And this is all according to Joey Kimbrough, my right-hand man. So the thing is that I like the federal.
It's where you're going to want to be when you file.
If you're looking to get into negotiable instruments litigation, I personally think, for myself anyways, that federal negotiable instrument cases is the way to go, because once you learn the Title 18 stuff and the Title 12 stuff from the United States Code, and once you learn the basic operation of things and the UCC, and you read UCC 3, and once you understand the basic operation of instruments and negotiation and endorsements and all the stuff, then you only need to learn PACER once. And yeah, every single sector is going to be a little bit different, like we already saw, but it's pretty much the same system. And you can use your same login as well. And it's all based off of the same body of statutes. Whereas state to state, the statutes could change and they have different fucking systems that look different and operate different and have different logins. So it's a pain in the ass, right? So although all of this looks overwhelming, it's, in my opinion, it's not that bad, because I'm only going to need to learn all this shit one time, and then I'm going to be able to just and then I'm really going to have it down. And these lawyers don't know any of this shit. So as I learn more and deepen myself into the federal system and PACER, I mean, I'm already probably leaps and heads. I'm already eating this brand new attorney alive. So the thing is that, she's not even following local rules at all. She is completely off the train track, and she's trying desperately to get back on the train track. And I'm just beating her down every step of the way. Right. So the thing is that when you understand the local rules and you understand the federal rules of civil procedure and you understand the federal codes and you understand PACER, It's just four main things you have to understand. Whereas on the state side, it's like endless amount of shit you have to learn.
It,
Because if one state's
yeah.
a little different or one state has a little different definition and they have a different login, it's just like, oh my God. To me, it's just like, no, you know.
If you
So
were to,
so
if you were to take an educated guess, and I know it's impossible to know for sure, how far off in time would you say this case is from actual discovery?
well, they have to answer the complaint. We're literally just trying to get them to answer the complaint. And that
Okay.
they just absolutely won't on any of these cases, all four cases.
What will happen if they just keep trying to not answer the complaint? At what point is some other
You
like
can write an order. I'm going to write an order at some point, and it's
oh,
going to be a court order to answer the fucking complaint.
okay.
I'm just learning. I'm just learning right now.
Is that a specific type of order or like
Nope,
what?
just like anything else. It says order up top, comes now, Brandon Joe Williams via Brandon Joe Williams, comma. We've been fucking around for a long time. You wouldn't say it like that, but that's what you're saying. Blah, blah, blah. We need to get this thing moving. We need to get this thing answered. This is ridiculous. Blah, blah, blah. This is why. Court order to have the defense answer each point of the original complaint.
Okay.
You can say just answer it. You can say answer it and then be more specific, affirm, denied, I don't know for each item. Or however you want to write it. You can write it's your order to write, and then the judge will either sign it or adjust it and sign it or whatever. I don't know how all that works exactly. I haven't even had.
Okay. I was just curious if because I it seems like the orders fall into like a classification. So I was just wondering how that
You can order that the defense attorney is not allowed to wear bright purple suits because it you have trauma of your father wearing bright purple suits, and you believe that the defense attorney is using that
would
as a
get
way
triggered.
to
It would
emotionally
trigger you.
trigger you.
Yeah. Okay.
And if that order gets signed, then now for the duration of that court case or whatever the order says, the defense attorneys are not allowed to wear bright purple suits.
I would have fun with this then, Brandon.
See what I mean? See what I mean? Now, some people might think this is very dry and very shitty. This is actually a beautiful exercise of logic. It's a beautiful exercise of your writing abilities. It's a beautiful exercise of sales and negotiation technology.
Yeah.
That you can use this. I consider this to be a rite of passage of being a man and masculine energy on this planet. I
I
think
would agree with that because you're standing.
either hand to hand combat or litigation. I feel like
Yeah.
every man on the planet should go through one or the other at some point in their life. I have not gone through hand to hand combat. And I'll tell you right now, litigation is the first thing I've ever experienced in my entire life where I feel I am going through a masculine rite of passage.
Sure. You're asserting your rights.
I feel like this is the first time in my life where, as a boy, I am becoming a man at fucking 38 years old.
Hallelujah. Let's celebrate
So,
that.
yeah, I think it's fucking cool. I think it's badass. And even if you don't win, you're going to win. You win either way. I
Yeah.
feel like in litigation, you win either way. You always win.
Well, when you're in the right, and those of us obviously who've been following, not just this case, but your work, the work that you've been putting forth this whole time. I mean, the whole point is to be on the right side,
Yeah.
right? Which the predecessor to that, of course, is doing the study. Like you've been at this for about 2 years now, I think, if I remember correctly, right?
Yeah.
So just think about that in context. Obviously, your audience knows that. People who are watching in my audience, they may or may not know that. I mean, this didn't just crop up in the last 6 months. This is like 2 solid years of like being all in on studying all the statutes, the Uniform Commercial Code, negotiable instruments, the US code, becoming intimately familiar with all of these terms. And now in the context of litigation, which is like another layer, becoming intimately familiar with how this specific process works, but it didn't
Yeah.
start here.
Yeah, and when you look
Right.
at the things that they're writing in opposition and the notices and all the stuff that they're writing, they're calling everything that I'm doing a debt elimination scam and vapor money theory. They actually aren't really talking about endorsements or
No,
negotiable instruments hardly at all.
they're inventing terms,
They're
going
just
back.
inventing,
Yeah.
they're just trying to say, "Oh, this is all bullshit." That's what they're trying to
Yeah.
do. Whereas uh in actuality, either they don't know or or they know and they're about to get fried. So it's one or the other. There's nothing in between really.
Yeah, because if someone doesn't really know how negotiable instruments work and they're just looking at this in a very superficial way, I can almost see why they would think it's a vapor money theory because they don't really understand how it works.
Exactly. Right. But it's okay because when we start getting into discovery or if we go to trial, even on this, like I said, drunk, beaten, unconscious,
Wearing a
no problem.
cucumber.
No problem. Everyone in the everyone on the jury could have an IQ of like 50. No problem.
That would actually probably be more to your advantage that they
Doesn't
don't
even
have a
matter.
super high
Doesn't
IQ.
even matter. They could all be 170. They could all be 60. They could all be old women, young women, black, white, Mexican, men. Doesn't matter. Give me anything. And I will effortlessly, drunk, beaten, and handcuffed, I will sway the jury. There's no question. Absolutely no question. And plus, imagine what I'll learn during that process. There's not a very high percentage of lawyers that ever make it into a courtroom for a trial.
Just make sure you televise it on YouTube.
Yeah. Yeah, exactly. Right. So going through this, I filed for an enlargement of time. That just means that I need more time to file the next thing because you get time limits on everything. There's time limits on everything. 10 days, 21
Sure.
days. So I needed more time because I said in here, I was like, look, I actually want to follow local rules and not just ignore them. So I actually want to actually try to do a meet and confer. So if we could just give me some more time so I can do that. And then this is, they granted that order in part. So I asked for like 2 or 3 weeks or something, and they gave me like 1 week or
That was
something.
the
I
judge
forget.
who did that.
Yeah.
Okay.
And that's when he vacated, or no, he actually vacated that prior to that point. But anyways, he says that hearing is canceled, right? So this is where the defense is filing in for motion for relief from local rule 7.3. See? And this one's actually fucking hilarious. Let me do a stop share
That
for
is
1
pretty
second.
nitpicky.
No, it gets way better. Let me pull up this one here. So I already have this one downloaded. It's going to cost me a fortune. Not really, but it's just not something I'm going to download. We're just going to go into I already got this one downloaded here. So let me do another screen share. So this is her motion for relief from local rule 7.3, which is the one that says you have to do the meet and confer. So she's trying to get around that rule. Which
So
again, like I
relief
said,
is like lifting the need to apply that rule, basically.
yeah, but those rules are law.
Okay.
Local rules are law. It's like it took me a while to understand that. It's like the United States Code, but for like local procedural operation. They are law. So, quote, asking for relief, end quote, is ridiculous. We have a system. The system makes perfect sense. When you're filing for a motion, you should come together, preferably in person, and talk about that motion and see if there's some way to settle. The court is trying to settle a dispute. They actually are trying. The problem is that settling a dispute means everyone stops making money. That's the issue. It's the monetary motivation is towards additional dispute, not towards resolution. But the local
So
rules,
for them, it actually benefits them to drag it on as much
of
as they can.
course, we're 28 filings deep. And like I said, the engine of the train hasn't even been started yet.
Insane.
So this is her trying to get relief from 7-3. And she says that I'm crazy and blah, 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 blah. And I have a website called onestupidfuck.com. And she gets into all this funny stuff, right? This was actually really funny, right? So she says,
She's trying to pin that against you.
this is where it starts to get into they're scared of the complaint when they go straight for reputation bashing. It's a good indicator, in my opinion, right? So
Ad hominem attack.
yeah. It's like we're in a debate about global warming or whatever, and you start attacking my personal reputation. That's just basically ding ding ding. The debate's over and you lost. You know what I mean? So It says here,
Oh,
the
Brianna, you're better
claims
than this. You're better than this. Come
the
on.
claims against American Express in this matter are not only nonsensical but brought in bad faith. Plaintiff runs an online business in which he offers to help others avoid their debt obligations by filing lawsuits against financial institutions like American Express. Indeed, plaintiff even blogs about this case and other federal cases to potential clients to show the success of his debt elimination scam. Now, what's interesting about this is some people have told me, like, oh, you should file for sanctions on the defense attorney for libel and slander. Okay, now the problem with libel and slander is that you have to prove that you've actually been damaged.
Mm-hmm.
This not only doesn't damage my reputation, it actually is the more people who find out about the fact that this is here, they're gonna have a field day. They're gonna laugh
It's
so
like
hard they're gonna
negative
shit themselves.
publicity is still publicity.
So because of the way I have my brand set up, all negative publicity is basically positive publicity,
Yeah.
and I did that on purpose from the beginning. Okay,
Yeah.
so the thing is that unless something happens where I could actually like prove to a court of law, because again, this is all public information. This is all public. Anyone can download this. Anyone can read this. So it is them just making shit up and trying to attack my reputation on a public forum. So technically it could fit under, I forget which one it is, libel or slander. But again, to file for libel and slander, I would have to say this occurred, which it did. And this is the damage that this particular lies and slander caused. And in my case, at this point in time, 4:22 p.m. on May 6th, none. It's hilarious. I'm over here laughing hysterically and drinking whiskey. It doesn't do anything. So
and honestly, I would feel the same way as you, Brandon, just knowing what I know. Like I would just be like, bring it on.
yeah.
You know?
So
It's fascinating.
now what I'm actually trying to do is the definition of the word payment means to perform on a duty, obligation, a contract. What I'm attempting to do is help people perform. If you were to really boil down what I do in a nutshell, is that I help people perform in the area of negotiable instruments. That's it. That's my whole website, my whole brand. Well, not every. I do other things too, right? They list some things down below.
With respect to negotiable instruments, this is.
But like my main thing right now, and like my main interest, and like kind of what I'm really focused on is assisting myself and others to perform properly and understand the various options of performance that they have, specifically involving unconditional promises to pay, otherwise known as promissory notes, and unconditional orders to pay, otherwise known as bills of exchange. Specifically and explicitly, I would say the core of what I'm trying to do is assist myself and others to perform and understand the performance aspects of endorsements. If you wanted to get even more specific than that, that would be like what I'm actually really trying to do. Now, what they're saying that I'm trying to do is I'm running a debt elimination scam.
Just amazing how they twist the language around.
But see that now the thing is though, is that now what they want is now they want us to have a whole conversation on why or why not it is a debt elimination scam, because now they have billables to do so. They'll say that I'm a Helsinkiite and that I'm from Gryffindor and that I sell purple ice cream out of the back of a 1964 Dodge panel van, just so we can have, oh, well, no, I'm not. And here's a picture of my car, and I'm actually not from Helsinki, and here's my birth certificate.
They're trying to put you on the defensive.
Well, they're just trying to talk about something so they can get paid.
Yeah.
Okay.
That's why it's so important to keep bringing it back to the principles of respect.
Yeah, you're all you're doing is you are dealing with a I don't know what you'd call it, like a dolphin on PCP. Okay. And you're riding this dolphin on PCP. Okay, it's like it's bull riding. Boom, bingo. It's like the rodeo. You're jumping on this defense attorney, and this defense attorney is going to do everything they can to try to throw you off. And you're up there with your big cowboy hat and your boots, and you got your one hand up in the air, and you're just, yeah, That's basically what you're doing. And you do that until the defense runs out of things that they can make up or whatever, basically. Now, this is in reference to a negotiable instrument case, because as long as you understand negotiable instruments, you can't lose these cases. It's physically impossible.
I think people need to grasp how cutting edge this case is.
Yeah. You cannot lose a negotiable instrument case. Absolutely, positively, 1 billion %. The only way you can lose is by not responding or not knowing how it works, or I don't know. I don't even really know how you could lose a case like this. I mean, if I lose, we're going straight to appeals. We're going to criminal cases. We're writing indictments. We're going all the way. All right, I'll file in court of federal claims. I'll go after everybody and everything under the sun who started, because technically, as per the information and functionality of negotiable instruments, I can't lose this case. Physically impossible.
Right. And I think people might be surprised by your certainty. I am less so, Brandon, because obviously I've been following your work, as I know many people have. And obviously you have a basis of understanding. So like you keep saying, like when you really understand how it works, there's a simplicity to it. You don't have to overcomplicate it. There's a simplicity to how negotiable instruments work. It's all there in the UCC. It's easy to learn and to, well, I don't know if it's easy to learn, but it's
Well,
simple.
UCC 3,
Yeah.
I bit into it and ate it in small chunks. Like, okay, for example, trying to read UCC 9, I want to literally hang myself. I want to like tie cinder blocks to my legs and jump into the nearest river and mafia style. I do not know how people can read UCC 9. I mean, UCC 9, I can't even get to the definition section without wanting to feed my skull into a wood chipper. I mean, I've tried multiple times and I just can't even survive even the definition section.
Secured transaction.
Yeah, just nightmare. UCC 9. And don't get me wrong, I will read UCC 9. But that's going to be like little like cube like bites that you'd give to like a fucking little bunny or something. You know what I mean? I haven't even tried to look at it in probably 2 months or 3 months. UCC 3, in my opinion, is not. So if UCC 9 was 10 out of 10 difficulty, UCC 3 is like a 2.5, 2.5 out of 10, in my opinion. I think the biggest barrier you're going to have to reading UCC 3 is just your own emotions, personally. But as long as you can get past that,
to read it,
as long as you can get past that, UCC 3, I mean, it's really not all that tough, in my opinion, really. Anyways, so getting back to this, moreover, plaintiff recently threatened American Express with criminal prosecution if it did not accept his settlement demand. Now, they have the evidence down below. We'll read it. I let them know that I was researching and looking into, and I had been looking into, and I am currently looking into, and I'm continually looking into how to write indictments, how to work with local DAs, the process of how an indictment gets built and gets approved. And we're looking over indictments, and I am going down that rabbit hole because we are going to go in that direction. If we can't get the stuff handled in a civil court, we are going to go down the criminal court lane. And if we can't get local DAs to prosecute the case, we're going to figure out why. And if there's no good reason why, then we're going to litigate against local DAs in the court of federal claims. And like, I've got a whole plan that basically, like, no matter how long it takes, no matter how much work it takes, all these cases that I'm doing and all these cases that I'm about ready to file, and I'm going to file the DMV case at some point and all these, there's no way I'm losing these cases. Absolutely physically impossible. If it takes me 10 fucking years, then so be it. So the thing is that
people should be paying attention to this. I mean, this is.
So the thing is that, I let them know that I was doing that research and I was looking into that. And that's because I am. It says in local rule 7-3 that for motions and stuff like that, we're supposed to come together and talk about this stuff. And it was all written, so maybe they got misconstrued or whatever. And you're going to see the actual email. I'll show it to you. It's down below this. But that was not my intention. I even said in the email that, look, we can forego all the criminal stuff. We don't need to go in that direction. We just need to handle it on the civil side. If we're going to, and that's when they broke off all communication and they said, like, from now on, all meet and confers need to be in writing, which is hilarious. That's just more
Like little
ignorance.
children.
They're like literally like little, I'm not kidding,
Yeah.
which is
Yeah.
hilarious because an attorney at law
Avoiding
represents
conflict.
children and persons of unsound mind, but yet they're acting like children, right? So it's
Let
actually
me correct
hilarious.
myself. They're not avoiding conflict. They're avoiding confrontation. It's different.
They're avoiding having to answer the complaint.
Yeah.
Everything, all 28 filings, or not all 28, because a lot of them are just trying to avoid answering the complaint. That's it. That's all they're trying to do. And get billables. They want to avoid answering the complaint and they want to get billables. Okay. So and with that said, like I said, there could be 50 attorneys in a room and I'll go down there by myself on my motorcycle with no notes. I'd love to meet with them. I'd love to have a meet and confer. I'd love to get this all straightened out. I really would. So I'm not in this for the fight.
Of course.
I like learning. I mean, if we fight, I learn. And if we close, then I win. I mean, that's the way I look at it. I win either way.
This is psychological self-defense. I mean, it's
Yeah.
the analog to physical self-defense, right?
I'm learning so much. It's unbelievable. Right. And it's just been a hell of a learning process. Right. So, when American Express requested that all future conferences to be in writing in light of this threat, plaintiff further threatened to come visit counsel's office and to tell this court that American Express willfully refused to confer with him if it did not confer with him, preferably in person. And you're going to see when I show you the emails, you're going to laugh hysterically. Just don't forget about this sentence because you're going to get a real kick out of the email I sent, right? This first one could be construed maybe in this way a little bit. This is just hilarious. You're going to see it when we get down there. Such behavior is wholly inappropriate and should not be tolerated. Accordingly, they're requesting relief from 7-3 so that they don't have to meet.
So what they're doing is they're kind of fabricating this psychological, I'm the victim kind of, did you see, guys, pay attention to what they did. They made themselves into a victim. I mean, themselves, it's like the corporation is a victim. How can that be? And they said, because we're a victim, you should relieve us from something that we have an obligation.
Yeah.
That's pretty much what they did.
Yeah, and if you wouldn't mind, I'll take a little break here, a little bathroom break, because we got a long ways to go. Would you mind?
Yeah, let's do that. I was thinking the same thing. Maybe
Okay, good.
5 minutes?
Yeah, 5 or 10 minutes. Let's do that.
Okay, no rush. I'm gonna pause.
We're just gonna leave it, leave it recording, or you want to pause it?
I'm gonna go ahead and pause it.
Okay.
And just before we get back into it, there are two things I wanted to say real quick. First of all, first thing I want to say is you're doing a really great job of explaining all this. So
thank you. It's my first time. I feel like it's kind of rough personally, but it's my first time. So I hope I can be, there can be a modicum of handicap because this is my first time trying to explain all this. And I really don't feel like I have it nailed down. It is my first time at the bat. You know what I mean?
Sure. So I'm just sharing with you that despite that, and I get it. I mean, the first time is always going to be a rough cut, but I think despite that, you are still doing a great job because I'm grasping this, and I'm sure the audience is. And the second thing I want to say is just personally, like, I'm surprised. Like, this is more, like, I'm learning more than I thought I would, basically. Like I was.
Yeah, it's just like if you've ever dealt with kids that are screaming and punching the ground and having a tantrum, you're ready for litigation.
Yeah. So I feel like my mind has been awakened to kind of a new perspective on it where I was a little bit, I'm not sure what the word is, like a little resistant or skeptical that I was going to get tremendous value. I mean, obviously I was open to learning it. Yeah. But I feel like just having gone through what you've shown me so far, a lot of things are making sense. I like the idea of thinking about it as psychological self-defense. I think that's a great way of thinking about it.
Well, a lot of people come to me who already have litigation or they're being sued. You can answer the complaint and you can file a counterclaim and you can structure it the same way you would structure a complaint like what I filed as the plaintiff. Like anytime anybody's coming after you for anything financial, bank, mortgage, anything. You can do what I'm doing.
Yeah. So I think like I said, I'm personally learning, and I think this is why getting this out in front of the audience, because I think everybody is watching this, like there is something for you here. And like so many people are uh, unnecessarily being oppressed. Like debt slavery is so oppressive. But once you start to realize that you have all the power, and this is just one way of doing the swordsmanship, if you want to put it that way. This is one way of wielding the sword. Very powerful stuff. So we can
Thank you.
definitely, I'm looking forward to seeing what you have next here.
Yeah, we'll just keep going through this docket. I'm not going to go through the other cases. We're gonna just go through the rest of this docket, and
Yeah.
then that'll be it. Okay. Um, so this is a great document because this is where they start getting into like a lot of personal attacks. So you can see here.
A debt elimination scam. I have to chuckle every time I see
I
that.
know, isn't that funny? I know.
Yeah.
Um, in the complaint, plaintiff's claims against American Express are premised on the theory that blah blah. That plaintiff is a lender. Plaintiff sent endorsed instruments and other documents not tied to anything of value, which is absolutely hilarious, to American Express's payment for his American Express accounts, and that American Express acted wrongly for not accepting these illegitimate forms of payment. Right.
Notice how they
According,
always use loaded language to respond.
of course. According to plaintiff, American Express's refusal to accept his illegitimate forms of payment is equivalent to peonage, enticement into slavery, sale into involuntary servitude, and forced labor. Right. Crucially, this is not the first time plaintiff has asserted these types of claims against a financial institution. Plaintiff runs a business called Williams & Williams Law Group, which he presents himself as an attorney in fact. I like how they put that in quotes. It's hilarious, right?
Yeah.
Um,
This is
and
we're
they
going
have,
to try to tie you to not being an attorney in law at law, which you aren't.
well, all of this is irrelevant to the complaint. That's the beauty
Right.
of it. It's just objection, irrelevant. It's really actually very simple. It's so again, what happens is that when they start throwing a child this temper tantrum, it's your job. Like if you say take out the trash, and they hit the ground and they start pounding the ground and they say I want ice cream, and you don't go into ice cream and start talking about ice cream and start talking about it. It's just like, okay, I'm gonna grab you by the arm, I'm gonna pick you up, I'm gonna brush you off, I'm gonna repeat what I told you to do. Take out the garbage. It's very simple. The problem is that they want to try to get you into 8 billion holes,
Yep.
and they're just praying to God you step in one of them. You see?
And just slowing the whole train down the whole time.
Well, it's all billables.
Yeah.
They're getting
Proving
paid.
once again
The
that we
more
were
they
right
do
all
this,
along.
the more they get paid. There's actual financial incentive for them to behave this way.
Yeah, it's all a business, folks. This
It's
is what
all a
we've been
business.
saying all along. It's all corporations,
Yeah.
for-profit corporations.
So the more bullshit like this that they vomit up, the more they get paid.
Yep.
Which is hilarious because they're getting paid like fucking peanuts, like $500 an hour or whatever it is. Which is like nothing. It's hilarious. But anyways, so well, I don't think these lower level attorneys are getting anywhere near that. That's probably how much the client's paying, and then the the main law firm pays the lower lawyer whatever they pay him. She's new, so who knows, you know. But anyways,
Secretly, she's envious of the fact that you're winning.
well, nothing. I mean, winning or losing is not really even something you can even winning or losing. I mean, you could be
You could be right and still lose in some
you could
cases.
be yeah, everything could be good looking great, and then all of a sudden something happens, and then poof, it's gone, and they have to go to appeals. And I mean, I'm not. I'm just like I said, I'm just learning, dude. I mean, like think about it. The more of this stuff you learn, and the more you learn how to do this, this is the way I look at it. If I lose this case, I can go to appeals. If I lose appeals, I'll be working on indictments and criminal case all at the same time. So I've got criminal case, indictments. I can if I can't get a criminal case done, I'm sure there's probably some way I could litigate against the DA's office in the Court of Federal Claims, which is a special court specifically to file complaints on like DAs and federal officers, and I don't know how all that
There's
works.
always the next. There's
There's
always the
always
next.
the next thing. I mean, it's for me to exhaust every single avenue, especially with how much public attention this case and the other cases are getting. The world's going to change whether I win or not,
Yep.
because I'm going to continue to publish everything I do, and I've got the next several years lined up of stuff that I can do to keep moving all these trains and each train and move everything along. So it doesn't really there's no, like I said, there's no way I am going to lose this battle. This battle will not be lost. It is physically impossible. The only way I can lose is by giving up.
We never give up, and you're inspiring other people to file their own litigation, their own
Yeah,
law.
there's nothing. The only way you can lose is by having limits. But doing what I do for if you're a man that does not have limits, and I don't mean that in a way that could be construed into like violence or something like that, obviously, right? Because my whole platform is all not, very against that. Um, but if you have no limits in terms of time and in terms of everything else, everything that happens in my mind is simply the next learning experience. And I'll tell you right now, if I have 16 cases going, which is how it's going to be here real soon, this year for sure, maybe not like real soon, but this year I want to have, more than 10, 15 cases going. So you get up to bat 2 times on every case. You have the case, and then if you don't make it, you can go to appeals. So you have to bat 2 times on every case. So that's 32 times to bat. Then you have indictments and criminal cases. I don't know how that works exactly, but I'm assuming it'd be like 1 time up to bat for each of those. So that'd be 16 times 3. That's what is that? 16 times 3. That's 30
48.
plus 48.
48. Yeah.
Yeah, so 48 times to bat. That would be basically like when I would start to feel like, well, shit. But that's going to be years from now, years and years and years and years and years. I mean, if I went that far and I still wasn't able to get anywhere, I don't know what I would do at that point. But
I just don't see that happening. I see there a big turning of the tides here, because the point is also for more people to start learning this knowledge and more people to take action. So it's not just you. I mean, you are pioneering this, and that's great. But this is the point is we're building community here. The point is it's not just one man against the world, so to speak. It's it's a growing movement,
yeah,
right? But it is
exactly.
kind of like you against the world in a way, because you are pioneering this kind of lawsuit. In a way, if we think about
Yeah.
it.
Yeah. So plaintiff describes the difference between an attorney at law and an attorney in fact. It says, however, a review of the California State Bar's website does not show that plaintiff is in fact licensed to practice law in California, which is hilarious because I don't even have any clients in California, which is even more hilarious because it's irrelevant on top of being irrelevant.
And you
Um,
never claimed to be an attorney practicing in the state of California.
no, God, no. I'd say specifically that I'm not in the state of California at all.
Yeah.
So it's actually hilarious. So, in its capacity, as an attorney, in fact, plaintiff offers services to help others avoid their debt obligations to financial institutions. Specifically, plaintiff assists others in filing lawsuits to discharge the debts accrued on their credit card accounts while keeping these credit card accounts open so they can achieve infinite money. And then they have some quotes from my website.
Well, she did her research.
Well, no, she got paid.
Yeah.
She got paid to write some shit on a piece of paper.
Okay.
It's all irrelevant.
So it was kind of
This
going
is
in
all
one ear and out the other.
this is
but-
all irrelevant. This is just an excuse to bill.
Yeah.
This is just an excuse to bill American Express. It has this nothing on my complaint had anything to do with my personal reputation. It has to do with
Sure.
the operation and functionality of negotiable instruments. Whether I'm the biggest piece of shit in the world or whether I'm an angel sent from God is irrelevant. It makes no difference. Completely irrelevant. Yeah, just means nothing.
They try to make it a battle.
It's like it's the
a
same
battle
thing.
of
It's like the same
personalities.
thing. Yeah, it's the same thing you're starting to see now where they say on micronations how they're saying how micronations are worthless and they hold no power and they're not recognized by the United States. It's all irrelevant. 18 USC 11 foreign government defined says irrespective of recognition by the United States. So They say that recognition by the United States is relevant to the discussion, but factually it is not relevant. So it would be objection, and then that objection would be involving relevancy. It's irrelevant. All of this information that we're reading right now is all irrelevant. Has nothing to do with anything. It's just billable hours. That's what it is. So we have here plaintiff emailed American Express's counsel to meet and confer concerning the motion to dismiss and plaintiff's anticipated motion to strike, right? Counsel for American Express called plaintiff, but plaintiff did not answer the phone. That's true. I don't answer random numbers. I don't know, right? They did email me. That's true. They did. And then we actually set up an appointment. We actually set up the appointment. I think it was like Thursday. We set up an appointment for a meet and confer, I think on Tuesday. Yeah, on April 16th to discuss the motions. Now, during that call, she said, hey, please send over any settlement demands via email before Tuesday if you want to. I said, okay, fine. So that's why I sent over the settlement demand, which you're going to see here.
So you guys did have a phone call. You had at least a phone call. Yeah.
Well, for like 2 seconds, just to schedule another phone call.
Okay.
But yes, it was very, very quick. We were off the phone pretty fast.
And then she realized how sexy you were just from that 2-minute call.
She was really nice on that call. It was a very pleasant conversation for a couple minutes. I told her I just gotten back from Austin, Texas, and I was just tired, and I just wasn't in the mood to talk. I was actually fucking wrecked. And so I just didn't really, I was not, so I needed like at least a few days. It was like fucking like a couple days or something after I got back. It was like very close. So I was just like not ready. I needed to schedule it for a few days out. In the letter, in the settlement demand, which is exhibit 1, we'll get into the exhibits, that I was currently seeking criminal prosecution against them, but was willing to forego these efforts if American Express accepted settlement demand, right? As a result of this threat, which is hilarious because that's what attorneys do all the time. They threat. So it's like, it's so funny. It's sort of like the person who steals all the time, steals. As soon as you steal from them, they like absolutely completely freak out. You ever notice that? It's like a human thing.
Yeah. Projection.
It's projection, right? So as soon as they perceive that anything within 2,000 miles could be considered a threat, they like totally flip out. Well, that's also an indicator of this profession, because that's literally everything, almost like a huge percentage of every communication I have ever gotten from a bar card attorney has had some type of direct or indirect threat of sanctions or filing a report for.
It's like a mafia.
It's like a mafia. Yeah, literally.
They act like they're in the mafia.
Basically. They act like literally children or persons of unsound mind. Which is exactly, they need attorneys at law. Attorneys at law need attorneys at law, literally. Okay. So as a result of this threat, American Express subsequently requested, and by the way, I have a lot of people telling me like, oh yeah, well, judges are bar cards. Yeah, but I don't know. I just don't think they're in the same category. We'll see. I mean, we're going to find out, but I just don't think it's the same thing. So when I say bar cards and all this kind of stuff, I'm referring specifically to all this goofiness that we're seeing here. Okay. Irrelevant billables would be a great way of describing irrelevant billables and threats is literally. Besides, okay, so of the cases when they write the response to the claims, the complaints, and they write the motion to dismiss, I'm pretty sure like the main attorneys that are on these cases are not the one writing those, because they're actually pretty verbose, and there's a lot of work that went into those. Those were probably written by actual like upper level attorneys, but everything else in the cases pretty much is all either irrelevant billables or threats would fit like pretty much everything else that I've experienced in these 4 cases. Okay. So, as a result of this threat, American Express subsequently requested all future conferral conferences be in writing. Um, let's see here. Give me 1 second. Um, okay. Um, we're recording now, right? Sorry, I was totally
Yep.
spaced out.
Yeah,
Okay.
we're recording.
American Express, in response, plaintiff insisted that he wants to meet and confer with counsel for American Express in person and offered to record the exchange, which is hilarious because you'll see in the email. I don't even need to tell you about this stuff. You're going to see it for yourself. Plaintiff threatened on 2 separate occasions that if American Express did not agree to meet with him, preferably in person, he would notify this court that American Express willfully denied his request to meet and confer outright. Blah blah blah. This is some stuff. Let's see here. Just some basic functionality stuff. Functionality stuff. Blah blah blah. What is this? They say I brought my nonsensical claims in bad faith.
When they
Um,
say in bad faith, like what would be another way of saying in bad faith?
I'm not 1,000,000% sure, but it's kind of like I'm pretty sure what they're trying to say is like specifically for some sort of like nefarious or non-positive or nonsensical reasoning, like
Almost like fabricating something.
harassment or
Okay.
like ridiculous, like to put someone into like a fearful state or just to, whatever. It's like bad. It's like not with the intent to confer and settle a disagreement or dispute. I'm not 1,000,000% sure. I've looked into it some and but I'm pretty sure that's kind of what it means, basically. Um, blah blah. Please let us not follow the law. We really want to not follow the law here. It's basically what they're saying when they're trying to get away from local rule 7-3. Um, let's see here.
Has been fruitless. Is that a legal term? Have been fruitless.
Never seen that before. There's a lot of new terms that I've never seen before that I'm seeing in this stuff,
It's
right?
very
American Express.
imprecise, their language, I have to say.
Well, yeah, it's all assumptions because assumptions create billables.
Hmm.
Irrelevant billables is the name of the game, right? American Express attempted on 2 separate occasions to confer with plaintiff concerning the motions. On April 11th, 2024, after plaintiff filed his motion for enlargement of time, he requested to confer with American Express concerning the motions. American Express immediately attempted to contact him. However, once the parties met, plaintiff admitted he was not ready to discuss the motions. The parties then scheduled the meeting to allow plaintiff sufficient time to prepare to discuss the motions. However, then it just says this threatening letter where it was the most horrible demon ever, and they threatened them. Okay, so now we're going to get into you guys are in for a laugh now. So now we're going to get into the all the attachments and evidence and everything. So this is all the stuff that they attached. Okay, so the first one they attached was let's see here. This is the declaration. So there has to be like a declaration attached to all the different things that they file and the motion to strike and all that. They have stuff from my website, my about site, talking about the California Bar Association, all irrelevant. OneStupidFuck.com, all irrelevant. Um, all this stuff, blah, 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 all this irrelevant stuff. You can always tell, I mean, not always, because my first time doing a lot of this, but when there's 9,000 different attachments, typically that's just because it's all irrelevant. It's a good indicator that it's just all irrelevant. It's like, why would
And
you
it's a
need?
good indicator that they have no sense of humor whatsoever.
Well, it's also a good indicator they have no defense.
Yeah.
Because look at all this. They took my whole exhibit A, they took my entire about page from williamsandwilliamslawfirm.com, and they took the whole thing and they copied it and pasted it.
Crazy. Got to get those billable hours up.
Oh, this is great work. I mean, this takes what, 15, 20 minutes to get all this put together? It's like, how much is that worth in billables? You know what I mean?
125 at least.
Yeah. Oops, what do we got here? Let's see. Uh-oh, we have an issue. Hold on 1 second here. Houston, we have a problem. Let me
I
pull
can't
that.
wait to see that email that you talked up.
Yeah. So let's get back into this.
My God, all these attachments to that one motion?
Yeah,
Insane.
that was 22. What if I just opened all of these at the same time? Maybe that'll work. There we go. And then 14 is going to go over here. There we go. Here is a bunch of a screenshot exhibit B of my homepage where she talks about in the thing, she's like, that I describe myself as a horny, racist, worthless bastard, which is hilarious. Again,
I tell
irrelevant.
you, they have no sense of humor.
It's all irrelevant. Even beyond that, it's just
Yeah,
all irrelevant.
I know.
Um,
But it does make it even more humorous.
this is 13. So now are we going 5? Is it 5? So this is just a screenshot of literally everything on my entire questions and answers page for Williams Law Firm, which is all entirely irrelevant to the case. And then we have this next one, which is how litigation works. It's a screenshot of my page, which is all completely irrelevant to the case. And then we have this is also, I think, how litigation works, which is all totally irrelevant to the case. And then here's my local and previous litigation page, which is completely irrelevant to the case. Here we go. Hello, Miss Bauer. I'm emailing you to schedule a meet and confer as regards to case number blah, blah, blah. Please see attached agenda as well as a PDF screenshot of local rules section 7. I am assuming the reasoning behind you not having a meet and confer with me for the motion you filed is in accordance with exemption 16-2C. But I would like to make it known that I am not in custody, so I'm not sure how that exemption would work. So I'm not sure. So I'm telling her that she totally fucked up in like the nicest way
Yeah.
possible. She didn't follow local rule 7-3. She didn't do the meet and confer. And there's an exemption section. In that exemption section, it says that if you're in custody, you can be exempt from having to do a meet and confer. I'm not obviously in custody. So I put that in the email.
It's a polite
But
way of saying that you completely fucked up.
yeah, you fucked up royally, right?
Yeah.
So I had a whole agenda for our call. I had a step-by-step thing I wanted to go over with her and everything. Um,
Of course, she found a way to get out of it.
she says she does not consent to being recorded. One of my lines is so I did actually let's see.
So you have like this call is being recorded on the line?
Yeah, so I have a different line that I called her from, right?
Okay.
That wasn't recorded because I was fine with that, right? So, dear Miss Bauer, I am writing to propose a settlement to the current dispute between myself and American Express. Blah blah blah. The terms I am proposing are very simple. So if you look at my original complaint, I have the relief demands are 153 through 156, right? If we can settle this situation rapidly, I'm willing to waive 154 and 155. So that was like 154 was like a refund of every single payment ever made on the account since the account's inception. And 155 was the $250 million.
That's a big concession on your part.
So yeah, so what I said was is that if they just do 156, which is the black card, then I'm willing to waive all the other aspects of relief. And I said 154 is the only item that actually costs Amex anything out of pocket. So if this settlement proposal is accepted, not only will it cost Amex absolutely nothing, I won't request even the court fees, comma, but actually Amex can begin making profit on the interest generated from the negotiable instruments on the new account right away. And then this is the part where they freaked out. I would also like it to be known that I have been doing extensive research into how to make a criminal indictment through the DOJ on this matter. I am preparing to create an indictment and personally contact the United States Attorney's Office in the Central District of California. His name is E. Martin Estrada. By accepting this proposed settlement, I would be willing to forego those efforts and ensure that no criminal indictments are submitted or requested.
I
And they
can
just,
kind of see why they latched onto that, of course.
yeah. So
They're
that's what I
looking for
said.
they're looking for anything to cling on to.
Sure, whatever. I
Yeah,
mean, it's billables, right?
right.
So I believe these terms provide a fair resolution and represent a sincere effort to avoid further litigation. I'm prepared to sign a comprehensive release and settlement agreement contingent upon the acceptance of these terms. We have already made a meeting to speak on Tuesday, 4/16/24 at 2 p.m. PST. I am open to discussing these terms further and making adjustments as necessary to facilitate a resolution. Thank you for your attention to this matter. And then this is my settlement proposal.
So she fucked up here because American Express had an opportunity to win without losing big, without having really anything out of pocket.
A bank can't really lose. I mean, when you
Yeah,
understand how negotiable instruments work, they can't lose. So it's really insignificant either way. If anyone
gotcha.
really knows how
That's
negotiable
true.
instruments actually work, it's honestly just it's totally irrelevant.
It's
I mean,
irrelevant.
this
Yeah,
is all irrelevant. I only wrote this for the defense attorney because I know she doesn't understand. But really, at the end of the day, it's irrelevant. It means nothing
yeah.
to American Express. They could care less. It could be $5 billion. That makes no difference. You know. Here's the next one. Please find the attached American Express's response to your settlement demand. And then
Interesting.
they reject settlement demand you outline in your letter in light of your threat to seek criminal prosecution. This letter further serves as notice that the telephonic meet and confer scheduled for April 16, 2024 is canceled. All communications in this matter moving forward, including meet and confers, must be in writing, which is hilarious because that's not what a meet and confer is. So again, it's just goofing. It's just
Little children.
tantrums, right? This is a tantrum.
Yeah.
Okay. Um, I have received your response to my proposal. This is me. And then there was some other people on the line that I also CC'd because they CC'd on me. I have not threatened anything in particular. I'm just being transparent in terms of my intention and activities. In fact, I offered to forego criminal proceedings. We need to have a meet and confer prior to my filing the motion to strike pursuant to local rule 7-3. The court prefers that we meet in person, like I showed you guys earlier, right? And I would actually be much more comfortable meeting in person, right? Now they're all freaked out. So I'm thinking like it can be a recorded meeting by all parties if that is more comfortable for you. That was translated into, he's trying to come down here and record everybody.
Yeah.
It's not what I said, you see. Or I will inform the court that you have denied the request for a meet and confer, which is like saying fuck the law, basically.
Yeah.
Right. No response. I think I was like maybe 2 or 3 days later. I'm not sure. I sent this one on the 15th at noon. And then this one was sent on the 18th at 1 p.m. So it'd been 3 full days.
Yeah.
And they were weekdays. They weren't weekend days. Because this one was sent on Monday, April 15th, and then this one was sent Thursday, April 18th. So, and I'm on a time clock. So you also got to think too, like I'm like not wanting to fuck around and wait 5 or
Sure.
6 days because I'm on a
Nobody wants
fucking
their
clock,
time
right?
wasted.
Yeah. Well, no, I'm on a clock. I have to get this done and submit it into the court
Yeah.
within like 10 or 14 days.
Got it.
I don't have a lot of time. So I gave her 3 days, but I don't have all the time in the world. So I emailed her again. I have not heard back from you by Monday, 4/22. If we cannot set up a meet and confer, preferably in person, I will literally come downtown and meet you in your office, comma. Then I will be noticing the court of a willful rejection of the meet and confer. And they reword all this like I'm threatening them and harassing them and all this kind of whatever wording that they used, basically, right? And then this is them writing a proposed order granting American Express's motion for relief from Rule 7-3. So
They'll do
she
anything
wrote
they
this.
can to keep it going. It's just insane.
So she wrote this, right?
Yeah,
So now we're going to go back to the docket. So that was just number 20. We just went through just number 20.
insane.
So here's me writing in, let's see. No, that's her file by, wait, revised. File by, her revised document. This is my opposition to the motion to dismiss. So we can get into this. So if you read through this, you can see this is all my response to their motion to dismiss, right? They didn't add, they're supposed to add evidentiary support to um, fighting against what I had to say and stuff like that. My claims are kind of self-evident in a way, because my claims are like, the definition of this is this, and the definition of this is this, and it's like the complaint itself kind of is the evidence. It's kind of a
Yeah.
weird complaint in that way, because a lot of it you can just look it up and it's all there. I don't need supporting documents necessarily. Like, you can just look it up on the USC, or look it up in Black's Law, or look it up wherever, and
Do
it's
you
all.
find do you find it takes you a lot, like how time consuming is it for you to put together these responses? Are you pretty fluent in this now, or does it still take like a reasonable amount of your time to do that?
No, no. I mean, Joey Kimbrough helps me. He's my counsel. He's my right hand man. He's the one who's won a lot of these cases, so he knows a lot about like the case law and stuff like that.
Got it.
We talk back and forth and go back and forth and put these together and work together and that kind of thing. So he knows a lot about the case law stuff, and then I know a lot about like the actual structure and the actual negotiable instruments and the kind of like the behavior and that kind of thing. I think I'm going to shine a lot more in-person discussions or teleconferences than I would in a lot of these documentations. I think a lot of this stuff is just kind of like pathetic, childish tantrum hand holding.
Yeah.
It's actually kind of disgusting. It's like a complete abasement of like all human interaction, and
And
it's
you
actually.
can raise an objection when you're speaking in court, whereas you can't really do that with all this paper trail. Like
Well,
you can, but
all
you
of
have to
this,
wait. You have to,
is all oppositional. Yeah, this is
yeah,
all oppositional, right? So it's all of this is all oppositional to everything she said, and then she's going to write everything oppositional to everything that I'm saying.
crazy.
So that's basically what it is, right? And like this is really interesting. Like, we haven't even fucking talked about the case or the complaint, and they're already trying to get it dismissed. It's like ridiculous. It's nonsensical. We literally haven't even talked about the fucking complaint at all. Like, not even like a word. So just going through and rebutting every single thing. I mean, if you can rebut literally every single sentence that they say, it's ideal. Leave nothing
Of
to
course.
chance. It's all oppositional, right? But you can read through this. I'm not going to go through all this. Um, Honestly, a good chunk of a lot of this stuff is just ridiculous. The whole thing is
Yeah, it's
ridiculous.
just
We should
still
be talking
taking, we're
about the
still
complaint.
off the trajectory of the main point of the case.
Yeah, we should be talking about the complaint, not all this bullshit. Right. So, and then going back. Um, and then this is that was a response to, that was a notice in opposition to the motion to dismiss, or motion, that was my motion to strike the motion to dismiss. I forget. It's something like that. And then here's opposition for the motion for relief from local rule 7-3. So again, everything they file, I'm filing in opposition.
Hmm.
Um,
Notice
and
to
then
filer of deficiencies.
yeah, this one,
That comes to the account from the court, right?
yeah. There was an error. Hearing information is missing. So that hearing was canceled, but the hearing was placed in one of my documents, but that's all right. They're just saying, just so everyone knows, that hearing that was originally approved is now canceled. But the computer like makes you type in like a hearing date. You can't continue. Or maybe you can, but I like couldn't figure it out. So I like just put it in there and they're just saying like, hey, real quick, just letting you guys know that's not that hearing was canceled. And then this is them saying like, okay, a couple more things and then we're done. And then this is reply in support of their motion to dismiss the case, revised. I don't know what that is exactly. Let's see.
That sounds important.
Oh, so she filed a motion to dismiss the case. I filed a motion. I filed a motion to strike or a motion or a reply in opposition to the motion to dismiss. This is the reply of that reply.
Okay, so this is coming from the defendant again.
So this is the 1, 2, 3 ping pong I was telling you about earlier,
Yeah.
where someone initiates and then one response, and then the initiator can respond to the response. This is the response to the response.
Crazy.
This is the third bat on that particular
Can't
motion.
imagine what they're saying at this point.
Uh, California district courts have thoroughly rejected the vapor money theory on which plaintiff's complaint is based on, blah, blah, blah. Plaintiff has not presented any argument or case law to this court to show that he has stated any viable cause of action against American Express. Again,
and he never can. That's like a tantrum language right there.
yeah. Well,
'Cause that's
that's
not
just
precise. That's not legalese.
that's just because every time they file the motion to dismiss, the first thing they're going to do is they're going to file a motion to dismiss. Again, it's always going to be everything that I've ever seen. It's always going to be failure to state a claim for which relief can be granted. That's always the reasoning behind the motion to dismiss.
that makes sense logically.
You could have a smoking gun and a room full of dead bodies. They're still going to file that.
Yeah, because they want to undermine the basis for the whole case.
They just want to throw whatever the fuck they can out there and see whatever the fuck happens and make billables.
Yep.
Okay. American Express did not violate these various rules. This is what I'm saying back. They didn't attach the evidence and kind of all the things like that. They're saying that they don't have to. They're saying that that's bullshit, blah, 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 when it's actually very clear. You just read it for yourself. It's very, very clear. There is no dispute as to the value of the documents and parcels plaintiff sent to American Express. So basically, like, I sent a bunch of 1099As, right? This is way back when I wasn't sure what I was doing. The 1099A argument is what they're referring to here, but like now at this point, the 1099A stuff is pretty irrelevant. I actually don't really care. My concern is not necessarily the 1099As. My concern is with the fact that I have actually done a rescission of my blank endorsement, and I have replaced that blank endorsement with a special endorsement on every single negotiable instrument that have ever been manufactured on all accounts since all the inception of all of the accounts. That's like primarily what I'm talking about. They're referring here to the 1099A, which whatever, I really don't care. I mean, I'm actually would love to have that conversation. Is a 1099A a bill of exchange? I don't know. I'm like pretty sure, but I'm not 100% sure. There's very little on the complaint that I'm not 1,000,000% sure on. But keep in mind, discovery can flush all that out. You never want to allege things that are just ridiculous. You know what I mean? Like, I'm pretty sure that the 1099A could possibly be a bill of exchange, but that would be an excellent thing that I would love to speak more about in depth. But it's not really all that relevant. The most important, I mean, it is relevant because it's in my complaint, but the most important thing by far is the fraud, the pulling of the blank endorsements and the placing of the special endorsements.
Yeah.
That's like 99.9% of the actual conversation. So let's say even if it is determined that the 1099As are not bills of exchange, it still doesn't it's still not going to stop this case. It's not even going to slow it down. It's not going to really make any difference, honestly. If it's determined that the 1099As are bills of exchange, then that just tacks on an extra $177,000 plus damages that I'll be entitled to. But who cares when you're looking at 250 million? It's insignificant.
Right.
It's just an insignificant aspect to the case.
It's like choosing your battle wisely.
Yeah, I want to focus on what matters, and what matters is the endorsements. That's what matters. Okay. Um, Talking about pro se. Um, the 7.5 and 7.6 local rules, which require motions to be supported by evidence. However, plaintiff is incorrect. A court may only consider the four corners of a plaintiff's complaint when assessing whether the plaintiff's. I mean, I don't even know exactly everything they're talking about here. It's almost like I just get
It's
so
like they're trying to,
irritated.
it's more hoops and more billable hours.
It's just a bunch of just yeah. It's just like shitting in their own hand
They're
and
at
then
this
like
point they're
throwing it at
vomiting
me.
out
Yeah,
whatever they
it's just like
can.
whatever. I don't know.
Crazy. But you have to still have to respond to it, I imagine.
Well, yeah. If you don't respond to it, then it becomes truth and law. You're basically agreeing. That's kind of what that's their whole plan. If they can produce a ton of irrelevant billables, something can maybe stick. Because then later on they'll say, this one thing where you're a purple unicorn was never opposed. You see?
It's like a war of attrition in a way.
Yeah. So, based on the theory that American Express acted wrongly in not accepting non-legitimate forms of payment. Now they're referring, I'm assuming, specifically here to the 1099A, which again is just not. It's not the basis of this thing really. It's just a small little side venue. Um, so it's not even really all that important. Um, whether the 1099A is or is not a bill of exchange is whatever. Not going to slow this case down even 1%. Really, it's not. Um, let's see. So we're talking about the bills of exchange here again. Um, a trademark cannot create
I don't know. I
currency.
was just reading that. It's
So they
hilarious.
have no idea. They have no clue. Um,
Or you're not giving enough credit. Like they're just so clever. Like they're in that clever mindset that they knew exactly what they were doing there.
I don't think so, man. I don't think a lot of people have any clue about any of this shit, to be honest with you.
Hard to
Why,
know.
why in the fuck would you be working for American Express as a lawyer if you knew any of this shit? You know what I mean? Unless you hate yourself, I guess. I don't know.
Well, one of my theories is that a lot of these people do hate themselves deep inside.
Maybe.
I
I don't
think
know. I mean,
I
sure.
think I think so. What drives
Uh,
one to behave like a child when they're an adult?
yeah. Um, Marvin versus Capital One. Pro se plaintiff alleged that he sent two documents, blah, blah, blah. Claimed to be promissory notes. So, that's irrelevant. I never sent in documents that claimed to be promissory notes, you see. Um, so they're referring to a bunch of cases. You can dig through all these cases too. I haven't done that. I've dug through some of them, but to me it's just kind of irrelevant because I know for a fact that my shit's super tight. I don't really, and I've been looking at fucked up documents and fucked up shit and fucking things up myself for so long that I mean, I don't really need to look at more of them, but I've looked at some of these and I may look at more of them. I don't know, but we'll just, but they're irrelevant anyways. I'm not sending in promissory notes. They already have them. They've already got the collateral security. So it's not like it's just irrelevant. Every time I put my credit card into a credit card reader, they were issued a collateral security instantly, digitally. Every single statement, every single piece of paper, it's all proof. I never sent them anything. I mean, I guess depending on how you can think of the definition of the word send, I don't know. I mean, I manufactured it digitally and then it digitally was sent to them on the computer all instantaneously within a split second. I guess maybe in that respect, I don't know. But there are all these different things that they're mentioning is not what I'm mentioning on my complaint. They're mentioning irrelevant aspects that have nothing to do with my complaint. The only part of this that has anything to do with my complaint is just the idea that is a 1099A a bill of exchange. That's it. That'd be the only point of contention here that actually should be discussed. Everything else is not being addressed. But the 99.9% of my complaint is not being addressed. Right? They're saying that no civil private rights of action for his claims under all these statutes of the United States Code, Title 18.
This is inappropriate. Again, this language that has no legal basis.
See, while pro se plaintiffs are held to less stringent standards than formal pleadings drafted by lawyers, see? The liberal construction does not require the court to conjure up unpled allegations, nor rewrite a complaint to include claims that were never presented. So it's like, how far does that liberal construction go? And it doesn't go this far, right? I don't even know why they're mentioning this because I'm not asking anyone to hold my hand or whatever. I have no idea. Plaintiff cannot ask this court to rewrite his complaint to include civil causes of action he never pled, or to ask this judiciary to act as his legal counsel. So first off, you can always write an order or whatever to add parties to the case. You can always add causes of action. You can do whatever you want. And I never asked for any judiciary to be a legal counsel. So I don't know why they're bringing all that up. Again, it's all just billables. And so the only thing that they've covered in this is the 1099A a bill of exchange. That's the only point of contention that has been brought up in this, but that's just a very, very, very small part of my complaint. Yeah. I don't think they either don't understand the complaint or I don't know. I don't know what it is. The meet and confer, if we could actually do it, and they refuse to do it, but if we could actually somehow get them
because they know that they're in trouble when they do that.
Yeah, I don't know. I mean, I would be more than happy to meet and confer, and we can figure it all out. Because that, as far as I'm concerned, the only point on my entire complaint that is up for discussion is the 1099A form a bill of exchange. I would like to have that conversation. I would like to learn more about is it or is it not. I believe it very well could be, but like I said, I'm very much up for discussion on that. In terms of all the other stuff, all the promissory notes on the account being generated every time I use my credit card, the endorsements, the special endorsement versus blank endorsement, all of that is completely not up for discussion. Absolutely not. I'll talk about it. I'll educate. We can have some fun, but there's nothing that I'm going to learn probably that's going to be new or anything like that. I mean, UCC3 is pretty fucking clear. So they're just trying to fuck around on that. And luckily that's 99.8% of my entire complaint. Not is the 1099A a bill of exchange. That's like a very small aspect about all this, honestly. And if I would have known now what I knew then, I would have just not even done that. I would have just focused on the endorsements. But because I had sent that in, I think it'd be a good discussion to have. I'd like to learn more about that personally, um, and see if maybe I could learn something in that area. But I don't think I'm not like closed down to learning. It's not like I'm like fuck everybody like blah 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 about negotiable instruments and endorsements. I just don't think, you read UCC3 and everything, and it's just like there's just no way that my complaint is going to get undermined. And I mean, there's just no fucking way, man. Physically impossible. I mean, look at how hard they're trying to not answer the complaint.
Sure. If anything, their resistance is demonstrating how strong the case is. Because why would they have to go and flail and throw rocks and do all these things if you didn't have a solid case? They would have been successful in dismissing it,
Yeah.
right? In my opinion, if it was baseless.
Well, we have to do the meet and confer in order to have a motion to dismiss anyway. So the whole thing is fucked anyways, because
Yeah.
we never did a meet and confer. So all of these motions are all fucked because they're none of them, local rule 7-3 was not followed. We're supposed to be the meet and confer. And again, this is my first time up to bat. I am learning these last couple is just more bullshit. We're definitely both starting to kind of like it gets shorter and it gets kind of like less crazy on these last two filings because there's just like everything's already been said and there's just like we both know this is the very last time we're going to be able to file. So these last two filings are shorter and whatever, and this is the last one that I filed.
So what could happen next? Well, actually, let's go take a look at this last filing. So this was just like 5 days ago.
So this is my reply to their reply.
Okay. And you don't
Um,
get infinite replies, is that right? Like it's just like
no,
one.
no, no, no.
No.
It's like a 1, 2, 3. Remember ping pong ping?
Oh yeah.
It's
Ping pong.
the originator reply and then originator's reply to reply.
Okay, got it.
Now, during that 1, 2, 3 ping pong, party B can initiate an entirely separate motion. So now you have a 3-point ping pong on the plaintiff side, and then you also have a 3-point ping pong on the defense side going simultaneously. That's a lot of what you've seen in this docket, and that's why the docket's 28 filings deep. And like I said, the train hasn't even started its engines yet.
Crazy.
But you also got to keep in mind, let's say they call me tomorrow. Let's say their motion to dismiss is stricken, and they immediately call me and they go, "Fuck it, we're going to give you a black card." That's it. The case is done. The case closes. It's over. So that the train engine was never started.
Yeah.
The train never left the station, and that's it. It's all over.
So my question is, because money is not, money, we're not, it's really currency, because the amount that they could pay in penalties is not really relevant.
It's irrelevant.
What would be what would incentivize them, or what would be their reason to capitulate?
I don't know. I guess going criminal. That's kind of another one of the reasons why I've been looking into that so much. A criminal case.
Yeah. So you probably did the right thing by mentioning that to them.
I'm not, dude, I'm like legit not trying to like sway them or manipulate them in any way. Like I'm just like straight up as fuck. Like I was already doing research and like the local rule 7-3 says that like you should be transparent in like what you're doing and your motions. And I just like fuck it. Like I'm doing this and I continue to do this and I'm just gonna let them know. And I didn't think they'd freak out. I don't really care. They can freak out all they want. They get their billables. I don't know. I'm just learning.
Well, I'll tell you what, I mean, I'm in the edge of my seat. It's like watching a good movie.
Yeah. And then my other cases have all sorts of filings too. The first case with Dan Hollerman and Compass,
Yeah.
that one's got probably, I don't even know, 20 something filings in it. And then the other two are
Crazy.
quite a bit more quiet. The first one and this one are both pretty wild, but the other two are quite a bit more quiet. The one for the business loan for AG Texas, that one we've been waiting forever to get my client to get approval for electronic filing. He just finally got it. It's like they've been like fucking sleeping on it. So that case is just starting to kind of get popping like this one, but that doesn't mean still, it doesn't mean it just means that we're starting the process of going through all the same bullshit again on the other cases. All the cases are all in the MX case, I believe, is like, well, no, I think the first case and the MX case are the first ones to where it's exhausted and now the court has to respond. So it's like we haven't even had a court respond into one of the cases really yet, I don't think.
So maybe show us, you don't have to show us the whole document, but maybe just show us like one or two key points from this response, just so we can kind of see how you handled it.
Just, you can download these and look at it. There's case law in here, and it's just defendants have dismissed plaintiff's arguments as meritless without providing any substantial evidence or legal justification for such a claim. Same thing with scam. They say that I'm running a debt elimination scam, and I'm trying to assist people to not perform. Well, my language is perform. They're saying not whatever on a debt obligation. They don't use the word perform. I don't know why. They don't know anything about negotiable instruments, I guess. So, uh, payment means performance, the legal
Yeah.
definition of payment. So performance is really what it is. Anyways, so it is required that a claim be dismissed only when it is apparent that no relief could be granted under any set of facts that could be proven consistent with allegations. Defendant's failure to substantiate their dismissal with evidence renders their assertions procedurally inadequate, right? Misleading the court. Plaintiff believes the defendant's unsupported declarations are an attempt to mislead the court because they're just talking about my website and like, oh my god, it's like obviously extremely irrelevant. This is a negotiable instruments case. It's hilarious. Defendants assert that their motion to dismiss does not necessitate the submission of evidence. However, in Trinzi versus Pagliaro, a motion to dismiss requires factual grounding through evidence or affidavits. Now, they put declarations in, but a declaration is not an affidavit because you got to keep in mind, if they put an affidavit into the case, that's under penalty of perjury. So if they put an affidavit into the case and then I prove that affidavit to be false and I prove that they knew it was false, they're going to prison. That's why they don't put affidavits into the case. They put declarations
It's all
into the case.
allegations, pretty much.
It's all declarations. It's all horse shit. You see? So that's another indicator. If there's no affidavits, then they must not believe it hard enough. Right? Bad faith allegations without proof. Defendants allege plaintiff's claims are brought in bad faith, yet they provide no evidence supporting such serious accusations. Legal standards require that accusations of bad faith be substantiated by clear evidence of such conduct. The Supreme Court in blah, blah, blah emphasized that a claim for relief requires more than mere labels and conclusions. Specifics are indeed necessary. Lack of conferral. They say that there have been no fruitful attempts to confer, but there really hasn't been any genuine attempt to engage at all. Besides those first couple calls, and we had scheduled something, and that was good. That was in the right direction. But then when they canceled that and closed up on me, I mean, that was it. I mean, I would have definitely loved to have had that call. I would prefer to meet in person. 7-3 says preferably in person, and it really should be in person. I mean, I agree with the court. I agree with the local rules. Why would you not? Why would you not just meet in person, have a coffee or go bowling? I don't know, anything. You know what I mean? If both parties are trying to come to a resolution of an issue, I'll do drinks. I'll do whatever. Let's go on a bike ride on the fucking ocean. I don't know, whatever. You know what I mean? Uh, so just talking about local rules. I mean, a lot of this stuff is just local rules, and it's just three of them: 7-3, 7-5, and 7-6.
Got it.
I mean, it's really just
So that was filed on it looks, the date I saw there was the 1st of May. So is there a deadline for the next response? And what does that have to, what would be it?
no, that's it. We're done. Everything has gone to the court now.
Because as you said, it's like ping pong ping. So that's already done.
Yeah, we've already pinged all our pongs.
So does the court have to respond within a certain period of time?
That's a good question. I actually don't know the answer to that question. I am learning. I am learning with all of you right now. I'm in the same boat.
Well,
So
at least the motions are done.
Yeah, everything's done. There's not really a whole lot else anyone can really say until the referee comes in and says something. I mean, that's pretty much we've both said everything under the sun, moon, and stars. There's nothing else to really say. So basically, what's going to happen is they're either going to approve the motion to dismiss, and then at that point we go straight to appeals, and then I'm going to start going into criminal, and then we start working on all the backup plans. Or the motion to dismiss is stricken, and then they sign my order to strike the motion to dismiss, and then at that point they have to answer the complaint, and then from there we move into discovery.
I guess we're going to find out real quick where the mindset of the judge is at.
Well, I don't know. I mean, I don't know. There's a lot to look over, but I still reread my complaint every now and then, and I'm still very happy with it. I don't have any desire to change or adjust anything in that complaint. I think it lays out everything really, really beautifully. It's mainly just definitions and basic functionality. I mean, I don't know if they see that very often. I think what they see often is this case law says this and fuck you and all this kind of thing. I don't think they see something so emotionless.
That's what I meant to say. Like when I said we're going to see the mindset, we're going to see if they can have true impartiality where they're really objectively looking at, because we can agree, and it is somewhat an opinion, but we can agree that you've put together an objectively strong, solid case based on truth and based on things that are actually true with respect to negotiable instruments. So we can agree to that, right? So my point is, we're going to find out really fast if the judge, the referee, has a sufficiently objective mindset that he can read through that and say, what I'm seeing is what we're seeing, which is we have a very clear case, and then we have a lot of attempts to distract and dissuade and, and
Well, they see this shit all day long. I mean, I mean, this is how the whole, I mean, I can't imagine being a judge. I actually kind of feel bad for them. Not like, I mean, it just sucks. Like, I wouldn't want to fucking deal with all that horse shit all day long. It's like worse than a fucking being a kindergarten teacher. It's like awful. It's like basically just reading temper tantrums all day long. Like,
yeah, unless
God,
they
it's
love it.
awful.
I mean, there's got to be a judge that loves doing it.
Sure, I don't know. Sure, whatever. I mean, but the thing is that it's just, I actually kind of feel, I don't know. I don't know what life they live. Like, I'm actually very curious. I have no idea. I'd love to meet a judge and find out what their life is and what they've been doing and all this kind of stuff. Federal judges, I believe, are all placed there through presidents or whatever. I don't know everything about this,
Yeah.
but they have like long track records. They're placed there by presidents or special committees or
Sure.
whatever the fuck it is. And it's like they've been around forever. They've been in the legal system forever. So this is not like the young defense attorney who's just fresh out of school. This is like, a judge is a whole different ball game. And I've done a little bit of background research on some of the judges and stuff like that I'm involved in, but I've never heard anything from any of them, and I've never spoken to any of them, and I've never had any hearings with any of them. So learning that and learning how that goes and learning all this stuff and everything, it's just all, I mean, I'm just kind of getting started on this. I see myself litigating more and more and more now until the day I die. I don't know. I mean, I don't need to learn everything in 5 fucking seconds. You know what I mean? I don't know. I mean,
Sure. It is a
if they want
long
to,
game.
if they throw the case out, you can also file for reconsideration and objection. So you can you can tell the judge he has one more shot to reconsider this case. And if not, it's an objection and you're taking it straight to the appellate court. And the appellate courts can come down on these judges sometimes. So if the judge knows that you're going to be going to an appellate court and he knows you know how to go into an appellate court, they're typically not going to be so quick to jump on something and dismiss it unless there's good grounds for it and that kind of thing. So if he does approve the motion to dismiss, there's going to be another thing, which is going to be the reconsideration and objection. And then that's an opportunity to get back in the driver's seat. If that's denied, then we go to appellate. And then I'm also going to be looking into criminal simultaneously. But appellate's right there, ready to go.
Amazing.
So, it's just all, I want to learn criminal. I want to learn appellate. I want to learn discovery. I want to learn trial. So whatever it is and whatever it takes is just all part of the learning process. But you get a lot of times at the bat. So really it just comes down to always objecting to everything and being clear and being open with your communication without writing 750 pages. You don't, even a lot of this stuff is just too much in my opinion. Um, the second thing is you just never give up, and you just always anticipate the next move, and you just never just learn from each individual motion and learn from each individual document, and just don't get hung up on trying to win, because you're going to have a very unfun time on this.
Yeah,
If
you
you're
got
just,
to
if you're in
enjoy
it
the
to learn
process.
it. I mean, think about this. If I get through this and then I go to appeals, or I do this, or I go to criminal, or do this, I mean, I'm going to be the most powerful attorney on the planet, basically. If I go all the way through trial, and I go through all the way through appellate, and I go through all this stuff, and I go through everything, there's not going to be a single thing I'm not going to be able to handle. And so, and if you think that Amex is the end of my infinite money train, it's not. I'll sue every single banking institution on the entire planet. And then also I'll take on 100 clients for every single banking institution on the entire planet. I mean, there could be 900 lawsuits all over the place. It's like this is not something that in my mind I'm going to lose. It's just I'm not going to win tomorrow. There's a big difference, you see.
Yeah, it's all about discipline and dedication. And I think that's what's coming across is that you are someone who is dedicated to your craft, but also dedicated to unlocking this freedom and specifically ending the debt slavery that is coming from improper use of the system. So
It,
it's
it
not,
it really just comes down to performance, and it really just comes down to endorsements. I mean, bringing it, I said that months and months and months ago, and I've never found anything deeper or more intrinsic. And I really do, at this point in time, I really do believe that endorsements is really like the core to everything. I just don't see how I can get any more basic or more deep than endorsements. It's just endorsements are everything. And you'll notice that they never mention anything about endorsements, not once anywhere, I believe, in all 28 of the dockets. I don't think there's a single breath about endorsements.
yeah.
When really ultimately that is the ultimate conversation.
Yep, and we could probably explore that more. And we've been going for over 3 hours here. I mean, not including the break. So I'm sure you probably, I don't know how you feel, Brandon, but I'm getting a little bit wary. And I think
Oh,
this
this is
is,
a good spot to end. This
yeah,
will be a really whole new level for a lot of my people. And
yeah,
like I said, I apologize if it seems a little sloppy, and I got kind of maybe a little bit tired here near the end of those things. But you can download all that and read it all for yourself. I'm still learning a lot. I don't claim to be a pro at this stuff at all, not even close. I think Joey Kimbrough is quite a bit more astute and quite a bit more powerful, and I'm very happy to have him as part of my team at Williams and Williams Law Firm. Um, and yeah, without him, I wouldn't be able to do all this at all, and without everything else, and without howtowinincourt.com jurisdictionary course. It's a very, very good
nice.
course. I highly recommend it. It's all text based. There is like a video section, but it's just like not really great. Um, and he even says that in there. He's just like, it's like just kind of some basic information. But if you're looking for more information, I think the Dr. Graves course is really good. Howtowinincourt.com without a lawyer. Yeah. So, and I'm just learning it day by day and moving day by day, and it's very, very freeing. I mean, any ticket, any lawsuit, anything that could possibly ever happen, you can defend yourself very, very easily. You can counterclaim, sink your teeth into people right away. And then also, if you feel that you need to be the plaintiff and go after someone, it's very, very easy to do. You don't have to pay a lawyer or go through a lawyer. You can do it all yourself. Um, Very, very powerful. So I'll be working on many, many more cases here over the next several months, including the DMV, which is going to be a hell of a case. And yeah, just get up to bat as many times as I can and swing for the fences as many times as I can. And as far as I'm concerned, in the back of my head, mathematically, at some point, we'll hit a grand slam.
Awesome. So you have an open invitation if there's ever a major milestone that you want to come on and discuss with respect to the ongoing proceedings, you know, whatever happens, if you want to come back and talk about that, if it's a win, if it's a learning lesson, it doesn't matter. I mean, it's all part of the learning. So you have a standing invitation. So obviously we're going to be watching this very with a lot of anticipation to see what's going to come. And just, yeah, just know that you have that open invitation if you want to come back on to talk about what happens.
Awesome, my friend. Thank you so much.
100%. And also, if you want to bring Joey on at any point, I don't know if he likes to come on camera even, or if you would want him to, but we could do a three-way as well at some point.
Yeah, that'd probably be fun. I don't know if he'd be down, but I can ask him for sure. He'd probably be down.
That could be interesting since you guys are both working together on the case. If you wanted to, yeah, just run it by him and see how he feels about it.
Awesome, broski.
Great job. So Brandon Joe Williams, obviously onestupidfuck.com and Brandon Williams and williamslawfirm.com. I'm going to have the links below the video as always, so it'll be super easy, and also to your YouTube channel. So to my audience, I know my audience already got a lot of value from the first interview we did, so I know they're going to get for a lot of value from this series as well. So thanks again, Brandon. Really a
Thank you,
treat.
my friend.
Awesome. Have a good night, everyone.